got 13 parking spaces already, but we'll be creating a further 23. So there'll be ample parking. We think that's more than enough. We also have nearby, about 200 yards away, the sports centre car park. And that has, we understand, or I understand, 100 free spaces 24/7. More than enough parking on site. And there really would be no need for anybody to park in residential streets or take up parking spaces on the estate nearby. More than enough parking. But I just do say as well, repeat myself, it's not really an issue for you today here when discussing licensing. And again, similarly, traffic. Now, obviously, some people will come by car, but you'll see on the plan, we have our own access road with a one-way system. One way in, you come off the roundabout, round back of the buildings, and then out another way. And that we can manage easily. We're happy with that. We're in the process of getting a highways report done, and we're confident that that will help exacerbate any issues that might be experienced with other licensed premises elsewhere in the village. We know that YOLO, for instance, they don't have that capacity, and cars will park on the main road, causing tailbacks. That won't happen with us, and we can marshal that adequately. People will be dropped off there as well, and that will also be the road for deliveries. So visitors will be coming off the roundabout, not going onto it, which I think is something that some of the objectors were concerned about. We've also, in the original plan, we designated an area as a taxi rank. That was really a mistake. We shouldn't have done that, because obviously only you can designate an area as being a taxi rank, and that's really just a drop-off point. But again, access advantage being it's our own road, so we can manage it. And we appreciate, obviously, with anything new, there's always a concern about antisocial behaviour, and that is obviously relevant. We're more than confident, bearing in mind the nature of what it is that we'd like to provide, that we won't attract troublesome people, because there's not really anything for them at what we want to do. We're also experienced operators, and we have more than adequate measures in place to deal with anybody who might be troublesome. But again, we're really confident that there won't be issues, or certainly not the issues that the residents are afraid of. We know that they are responding to the suggestion that this is going to be some sort of stack festival site, 800 people. It's not like that at all. We'll have our own security staff, as I've said, also extensive CCTV. So in terms of the proposal itself, I'm not sure that there's a great deal that I can add. I'll move on now to the objections. Now, Mr. Soderquist did tell me, or hinted to me, that if I came to a natural break, I'm happy to put my hand up and say, if you want a comfort break, that's fine. Or if you want to box on, either way, that's fine with me.
I think we're okay at the moment. If we may stop you mid-flow, but we'll try as much as we can.
All right. Mid-flow, is that a pun? Yeah.
Right, I've just been informed that the live stream started just after 11:15, so we're live now. Okay?
Chair, boxing on. Just before responding to the issues that are raised by the objectors, I think it's useful at this sort of juncture to briefly reflect on the law. I tried carefully. I know you've got your own solicitor here who will give you advice accordingly, but just to remind ourselves, in this context, the onus is on objectors to convince you that we here, despite everything that we've said, conditions, etc., would be incapable of promoting one or more of the licensing objectives. And it's evidence-based, obviously. And I accept the residents will often complain in that sort of context, particularly with a new license, well, how can we predict the future? And I know they can't. I understand that argument. They don't have a crystal ball. But we're fully conscious of the fact that there is a robust enforcement procedure. So if it is the case, God forbid we get this wrong, something can be done about it. And we know too that we will always be under the spotlight until everybody becomes confident in us and understands that what I'm explaining now is what we will deliver. So it's important too that we don't stray into areas that aren't relevant. Planning, for instance, that's for another forum at a later date, dealt with elsewhere. And finally, as well, I think an equally important point, this is not a local referendum on whether we can or can't have a licence. I know that there are a large number of objections, but that, with respect to everybody who has objected, is irrelevant whether there's 1, 10 or 100. It's all about the evidence within those objections and whether they deal with and whether they convince you that we would fail to promote the licensing objectives. That's all it's about, not numbers. So if I could turn to the first objection that I'd like to address you on, and that's the Town Council, which is page 213. Yeah, lady's here from the Town Council, so she'll have her turn in due course, but I just did want to reflect on this particular representation for what it's, I don't want to say it's half an objection, because that's not right. It is an objection, I understand that, but having read it, you can see that the Town Council do note the changes that we've made and are complimentary on the things that we've done to try and assuage the concerns. So, for instance, the Town Council say that they are pleased to learn that security will be site 24 hours a day. It will be. They say, too, that they are pleased to learn that ongoing noise assessment will be done. That's right. We'll be monitoring noise continuously because we have that condition. Changes to the outdoor alcohol sales times within the application, yes. So these are things that they are applauding us for. They talk, too, that they would seek to seek relevant action, potentially including some signage to help to address the issue. That's public safety, roads, etc. Happy to do that. There were concerns about the emergency exit over the small bridge. Yes, this is something that's been raised by a couple of objectors. There is one of 2 emergency exits, escapes, which is the bridge that goes over the pond, and we'll be making some improvements to that. And I think the suggestion will be, well, that's just not adequate, it's not good enough. But with respect to anybody who might say that, this application has been considered by health and safety, it's been considered by fire as well, and they are content. So they are the experts. But as I say, it's one of 2 emergency exits, as well as the main entrance and exit. You'll see that on the plan that we've provided. Talked about as well, separate the premises from the river. We've had those conversations with the Environment Agency. That's why we've created the garden. We have our own fence, they have their own wall, and the garden creates a gap. I mean, I know that some of the residents have discussed the potential for people falling in the pond. I don't want to be flippant, but to actually get to the water, which I think most of the time is about 6 inches deep, you'd have to fight your way through reeds and all sorts of different things to get there. But, you know, I understand it's a potential risk, but I think we've already dealt with that. They talk too about our assurances in both of our meetings that this would be a family-based environment. Proximity of the river, I've dealt with that. Reassurances that a full safety assessment will be carried out, relevant consultees and consideration given, correct safety measures to separate the river. Well, we're doing that. We will do that. That's part, you know, that's our responsibility, health and safety. We'll have to have fire risk assessments. We'll do all of those things. So that's why I say that this is sort of a half-hearted, and I'm sure I'll be corrected, a half representation, because we're doing the things and that's been acknowledged that they have asked of us. Then the next representation is Mr. Grunnett. And Mr. Grunnett represents Mr. Young, who's here in the audience today. Mr. Grunnett and Mr. Holland are representing what I will call trade objectors. And with respect to them, and they're perfectly entitled to come, by the way, I'm not saying that they shouldn't be here, but their job is to throw as much mud in our direction as they possibly can in the hope that some of it sticks. They have their clients' takings to protect. They don't want us to open because they see us as a threat. But I'm sure you'll be alert to that fact. So Mr. Grunnett's letter, page 101. Paragraph entitled Lack of Transparency. That, with respect to Mr. Grunnett, is simply not true. We've been transparent throughout. We've had meetings. We've spoken to everybody who wants to speak to us about what we intend doing. We have not sought to hide what this proposal is all about from anybody. Now, it's true to say we've not had conversation with Mr. Young, well, because he's a trade rival. We wouldn't want to be telling him what we're up to. We don't want our ideas stolen. But there can be no criticism of us for not having had that conversation with him. Then over the page, the licence does not, for example, propose that the sale of alcohol would be ancillary to food or that food would be available at any particular hour of operation. But it's correct, but it isn't at the minute in Rialto's. But as we've said for Rialto's, the premises itself, we're going to continue trading as a restaurant. And as you've seen, we've provided all of these food stalls, and that's part of the concept, an integral part of the concept. So we've explained what we intend doing. Capacity of the venue. He talks about the potential capacity being over 1,000 people. It's 350, nowhere near that figure. It was never, ever likely to be anywhere near that figure. Talks about toilet provision. We've dealt with that, and we comply, well, we over-comply with the relevant BS standard. For the external area, he says, appears to be alcohol-led bar operation. Well, it's not. You can see from the plan what we intend doing. Live and recorded music, yes, we will be providing that, but subject to the inaudibility condition, which he doesn't refer to in his letter of objection. Dispersal, it's not a pub or a nightclub. People will come and go. They may not stay very long with us at all, or they may stay for a couple of hours. But it will not be the case that we'll be turfing out hundreds of people into Pontyland at a sort of kicking out time, as it were. He also talks about the exit leading onto the main street. I've explained one way in, one way out, and our system for managing that. Talks about the taxi rank. Well, we won't be creating a taxi rank. That's the easiest way of dealing with that. But in any event, we own the land at the back, by the way. That's ours. Village has limited parking. I've addressed you on that. We do have parking, additional parking, but there is parking nearby. But in any event, I don't think that will ever be a particular issue, because people will be coming on foot, people from the local area. Insufficient transport, same point there. Mainly locals, not always, but mainly locals. Summary. Our client's concerned by the detrimental effect this will have. Well, I suspect that's on his takings rather than the village. As part of hospitality sector, our client's concerned that their reputation will be tarnished. I won't say anything about that. And then that's Mr. Grunt dealt with. Oh, sorry, I beg your pardon. That's his representation dealt with. Then we move on then to Mr. Holland. Mr. Holland talks at length in the first couple of pages about another application, a variation application that was made before I became involved. Sorry, I beg your pardon, 133. First couple of pages are with respect to him of no bearing on this application. There was a previous application for a variation. That was, as I say, before I became involved. That application is withdrawn, has been withdrawn. It's got nothing to do with what you're considering today. You have an application before you, and that's what we'll be concentrating on. Then page 3, he talks about my client has no objection to the changes as they relate to the restaurant. Well, we're not really changing the restaurant, that stays the same, and it will continue to trade as a restaurant. The internal area, he says, he notes that we will continue to trade in the style of a restaurant, correct. External area. The external area consists of 2 elements, he says. There's no issue between us here either. He describes the application. Then the park. It's not a park, it's as I've described it. It's not a festival site, it's not the meadow. It will be vastly improved by us if we are allowed to do what we want to do. And he describes the park is currently a meadow. It certainly is not, and you've seen the photographs there. He talks about then that we describe stylish and relaxed, intimate surroundings, make it a perfect romantic evening or a family gathering. That's exactly what it can be, if you allow us to do what it is that we would like to do. He then talks again at the bottom of page 4 about the variation application. With respect to him, totally irrelevant, not what you're considering today. He then talks, page 5, it appears tolerably clear that the applicant's intention remains to trade some form of permanent outdoor festival site. No, not the case. Supplemented cheap and cheerful food, again, not the case. Construction of units is now is not clear, emulates semi-box park style operation, again, not what we're up to. By the way, his client does operate a box park, the Stack in town, but that's not what we're intending doing. He talks then further down, halfway down, the proposed operation. Essentially, this application seeks to bolt a large alfresco drinking park to the restaurant. It's not, it's the market square. That's what we're aiming for. That's what we've described. Then further down, people carrying on drinking until midnight. Well, they can't because the external area will be closed and staff will be clearing people away. It closes at the times in which we've described in our application. He mentions coronavirus as well. Well, this will be a permanent feature if you're kind enough to grant the license and we get through other hurdles. It's not just about coronavirus. It is here to stay and it will become part of the village and the environment. He talks about his client having trading presence. Yes, he trades a barn nearby, and, you know, I have nothing to say about that. Talks then about planning. Well, again, with respect to him, this is not a planning application, it's a licensing application. Then he talks about one of the unique features of Pontyland is the provision of high-quality hospitality operations, including my clients within the village setting. Well, we have absolutely no conflict with that, we agree, and we will add to that. Goes on again to describe us as a box park, not true, self-evidently not true. Plainly alcohol-led, with substantial bars being supplemented by food, again, simply not true. Talks as well on top of page 7, doesn't appear to be any wet weather protection. Well, there is, because you've seen it on there's sort of awnings, these canopies, you've seen it on the drawings, there will be. And then we'll be in competition for a night out with drinking circuits on Tyneside. Just simply is not. We will be family-friendly premises. There will be nothing that we are doing that will be of interest to people who want a night out in Newcastle. That sort of night out. Bearing that in mind, his suggestion that will cause crime and disorder, public nuisance, again, with respect to him, just doesn't bear very much examination. He says then that our clients, who he characterises, I think, as troublesome individuals, will then try to go to YOLO. Well, why would they? I mean, they'll stay with us. If they go to YOLO, that's fine, but they won't be troublesome people. They will be people from the local community. We are not intending, will never attract a different type of clientele, locals in the main. Talking about other premises may then feel obliged to let standards drop. Well, with all due respect, that's a matter for them and, you know, how they run their businesses, but it may actually have the opposite effect, that they improve their standards. Specific concerns, alcohol and open water is a dangerous mix. Well, you know, describe, we've got the fence, we've got the wall, and I mean, I'm sure you're familiar with the point of that particular, you know, the idea of you falling in and then getting yourself into difficulties. It's not like Durham where you've got students dropping in the river, you know, when they're drunk. It's not like that at all, but there are barriers anyway. Pedestrian access, again, I've dealt with that. Permanent stewarding in place, again, I've explained that. That is not because we expect trouble, or there will be trouble. Page 8, he goes through the conditions. He doesn't seem to think much of them, but I'll just repeat that they were the conditions that the police asked us to agree to, and we did readily. Then precedent. You know, this is something that is often said in licensing applications. The reality is, what you do today, no matter what you do, it doesn't set a precedent. Every application is judged on its own merits. If somebody else comes along with an idea in Pontyland, you'll deal with it, bearing in mind what they have to say. You do not set a precedent by granting a license to us today. He also talks about planning. It's quite right. He sort of I think, partly quotes the relevant condition. 6.11.2, whilst it would be preferable for premises to have either an appropriate planning consent or a certificate of lawful use and development, the licensing authority appreciates until all necessary permissions are granted, the occupier of premises cannot lawfully engage in any activities, etc. Yes, so licensing authority determine the matter in relation to premises yet to be considered by the other, because inevitably one application will always be determined before the other. The decisions are not binding on one another. So there's nothing stopping us making this application at this particular point, but we know that we've got to, again, if you'll grant a licence to us today, we've got to go through the same process with planning. Again, he talks about, finally, this setting a worrying precedent. Well, I've dealt with that. Each application on its merits. His documents he has produced, if you bear with me, I'll grab a hold of them. I mean, there's not really much to be said. I don't know what page they are in the supplemental agenda. Yeah. All right. He asks you to consider a plan which accompanied the variation application. And we can spend time looking at that if you want, but I don't see why it's relevant. It's a different application that we proceeded with. Then there's an aerial view and a street view. Well, there's nothing to be said about that. They are as they are. Then can I deal, well, sorry, I was tempted to go through some of the residential objections, but bearing in mind, I know you and I, Chair, have done a couple.
I think we'll be here all day. Well, we'll be here all day most likely, but we'll be here all week if that was the case.
I think indeed, but I remember the last time I had a hearing before you, you very politely reminded me that you're an experienced committee and that you didn't need that. So I shut up at that point. So I'm not going to go through all of them, but there's one or two, one, all right, I can see you twist one, that I will go through if you don't mind. And that's Mr. McClure, which is page 189 in your bundle. I only pick on this one because it's the most sort of hyperbolic of all of the objections that we have. And Mr. McClure talks about Ponteland is a delightful, quiet, semi-rural town with a village atmosphere and a strong community spirit. We know. Sonny and Paul live there. It's their home. It's where their families live. He talks too about maintaining a well-balanced competitive environment. Well, this process that we're engaged in this morning isn't about protecting other people, but I don't see any conflict with what we propose and what he is concerned about in any event. He talks then about an introduction of a very different type of clientele. No, not the case. He then, over the page, talks about late provision until midnight. No. Talks about judging by similar provision elsewhere. The music will be loud to create atmosphere and the staging very brightly lit to highlight the acts and performers. Musicians, singers, DJs and the like. Well, that's not what we're providing, and we've given you a condition that we would maintain inaudibility anyway. The fact that it's planned for an entirely outdoor setting with no natural hedges, trees or vegetation, well, I've described what we're doing. All the planting remains. We'll be doing more planting, and we're creating the orchard, and that has to look right, and that inevitably means that we'll be doing lots of planting, which will enhance that area enormously. Clearly not a facility intended to draw viable patronage from the village itself. It is. That's precisely what the intention is. Designed to offer similar attraction to those in the city centre, Pilgrim Street, Quayside, no. Consideration will be given to means of transport, again, most people coming on foot. Public nuisance. He talks about you as public servants having an obligation, effectively, to refuse the application. Well, that's not the case. What you will do, I'm sure, is take a very well-balanced view, having considered the evidence, as I'm describing it to you this morning. He then talks about football matches. Well, we haven't asked for films. We haven't got a screen. We won't be doing that. You cannot have football matches and try and attract families at the same time. It just doesn't work. So we won't be doing that. No films, no screens. Talks about a significant risk of fire or explosion. Again, the Fire Authority, Health and Safety are aware of the Fire Authority attended 2 meetings with the Town Council, so they are not objectives, and they are the experts. Escape routes, again, that is dealt with. So I'm not going to dwell on that any further, or any of the other potential reps. But what I would like to deal with, as I'm wrapping up, is Mr. Walton's acoustic report. That was sent to us yesterday afternoon. I got that on a train as I was heading back north. What I'd like to do, with your permission, sir, is just invite Dr. Doherty, first of all, because the report says he doesn't know what he's talking about, effectively, to just address that very briefly, and then we can move on to closing my submission. So, would you like to just first of all introduce yourself?
There's a microphone back there if you'd like to go to the microphone.
Do I need to switch it on, or is it's on? Okay. My name's Douglas Doherty. I have a PhD in musical composition, which may sound a bit weird. I spent most of my time doing computer music research and looking at the acoustics of musical instruments, spaces and rooms. Since then, I've taught acoustics on the undergraduate degree at Newcastle University, and I've spent the last 23 years working in acoustics, designing recording studios, working with bars on noise, limiting noise protection, and exactly this kind of thing. So I'm not I don't have the qualifications that the Apex guys have, but I have over 20 years of experience and a lot of knowledge to bring to bear.
We got their report, as I say, yesterday, and you've had the opportunity to read it. Have you got anything you would like to say about it?
The bulk of that report clearly is accurate and correct. There are one or two. The particular thing that should be noted is that the Apex report only allows for the 6 metre high barrier. It doesn't take into consideration the construction of the market, where we have significant additional barriers between the people talking and the nearby residents.
What about the buildings as well? Because there are buildings between what you've just described and Mr. Walton's property. That's not mentioned in the report either, is it?
No, because there are tall, basically they form a barrier, and I think very little will get through there. He's quite some distance from the venue, and those roads are fairly busy as well. But no, I think in that direction, the transmission is not an issue.
And also, no account was taken for the canopy that we'll have. Will that have effect?
I mean, that would not have a significant effect, I think.
But might it have some effect?
Yeah, it'll have some effect.
And also, I think, is it not the case that the Apex report presumes that we'll be having bands on?
Yes, yeah. I mean, I think that probably they were misinformed about that. So in the Apex report, the patron noise, I think, is that how you describe it? Yeah, the patron noise is the noise that we should be considering, and I think that on the basis of those figures there, with the additional attenuation created by the 2-storey high barrier at one position and 1-storey high 2.5 metres wide barriers, I am confident that we can achieve the inaudibility criteria they talk about, which is 10 dB below the background noise level.
So you stand by the conclusion in your own report?
Yes, I do, yes, even though the figures are slightly altered. Yeah.
Thank you.
Chair, it would only be fair of me, I suppose, to... I don't know if anybody has any questions of Mr. Doherty at this stage, or do you want to just allow me to wrap up?
No
questions.
Right, okay. Then, Chair, moving swiftly on, there were some additional documents that I got yesterday as well from Mr. Gibbs, against us, but suggesting some pretty prescriptive conditions. What Mr. Gibbs did not share with us is that he operates the 7 stars. He operates the 7 stars. He didn't share that with us in his representation. I'll let you draw your own conclusions. So, Chair, that's really all I want to say, apart from, with your permission, just inviting Sonny and Paul to say anything. You know, they are passionate about this. They've invested a lot of time in it, and it might be they have 1 or 2 things that they would like to say themselves. If I've left anything out, Paul?
No, I think you've covered.
The thing that hurt us the most was the incorrect information that went round from when we first spoke to licensing, what we wanted to do. I've been round the country and I've looked at various things that are there, Altrincham Market, Richmond itself, and what these people are doing, they're offering a venue or an area where people that you can help sell their own products. The reason we're having licensed, that we want it licensed, is because we're selling alcohol. But there's so much more to this. Going back to Victorian times, when you have an old-fashioned market square, is our vision. And when you go about the country now, a lot of people have done things but not quite got there. We've just got enough land to do this and to make it very special. Ponteland itself as a village, being there nearly all our lives and owning very, very, very relevant properties. I myself, the Diamond and then the Smithy, which are listed, know what the conservation area means, and that's all I will say in connection to that. And we want to create something that is very special. Ponteland has only got Broadway and it's got Merton Way, and with the best will in the world, the concrete blocks, and they look dreadful. What we want to create is a new village centre that is very special for the people of Ponteland. We're not doing this because we want to do a festival. We're doing this to put something back in the village, and when we're gone, it's still there and people talk about it. And I think that's basically all I need to say. I don't need to say any more. I will say to the objectors that before planning, we will have an open house where people can come and see exactly what we're doing, and they'll have a walkthrough and they'll be able to see everything. And to all of them, individual, they can come and they can sit and talk to us and put over their concerns, which a lot of them we've seen, and we will answer everyone. And I think that's, because me and Sonny are heartfelt about this, we know what the village needs. We know what's going to take it to its next stage. There's a lot of houses going to be built roundabout, already started. There's a lot of younger people. And we've got to cater for both the old and the young. And it's all right on this site if you just say, right, we put a block of flats. Ponteland's got too many flats. It's got too many. It needs something in the village of character. And that's all we're proposing.
Great, thank you. Right, members, are there any questions to the applicants? You're going to find right, Councillor Sessford.
Thank you very much, Chair. I didn't ask a question before to the, I thought I'd do them all in one go. So, now clearly, looking through all these objections, I've came up with quite a few questions. I'm not going to ask them all now. I'll ask them sporadically throughout the process as we go on. The first one I want to get out there, I thought it's important to get this out there first, which is you've offered a condition to have a maximum capacity of 350. What I want to do is, if I just have a look at page 13 of your booklet, please, where it says on the top, the capacity of the site will be strictly capped at 350 visitors. So I want to make sure that we know what the site is. Okay, so just a second. So is the site the new piece, what has been called various names, the orchard, the meadow and whatever else the other name was, or is this inclusive of the whole complex, which is the restaurant as well? So in other words, is the 350 total for everything? Is the 350 include the restaurant, or if not, what is the additional capacity of them both joined together?
Sorry, sir, if I didn't make that clear. 350 outside in the orchard. The capacity of Rialto, the restaurant, would not be included within that number.
Okay, so therefore, I mean, I don't know what is the capacity of the restaurant?
120 covers.
Okay, so it could be 470 in total if they were to move after their meal alone. If they were to move after the meal, you'd still have 350 capacity in the orchard, would you?
Yeah, yeah.
So you couldn't have 350.
Couldn't have 470.
Okay, I just wanted to get that straight in my head first. I mean, you may have made it clear, just maybe not to me.
Can I cut in here just for a second? Did you not offer a condition of reducing it to 250?
No, 350.
350.
Maximum. I'll ask a couple more, if that's all right, Chair?
Yeah.
Yeah. Okay, my second one, when I find out where it is. Right, just a very quick one. You mentioned there that sales outside would finish at 22:30, 10:30, in layman. What time would you see that the outside area, because the licence goes at 12, I mean, what time, so you stop selling at 10:30. I mean, I might have got this wrong. I'm quite happy to be told I've got it wrong. So it'll be open till 12 or no. So that's the bit that I'm a bit confused about. What time are you expecting the people from outside to vacate? Sale of alcohol finishes at 10:30.
Yeah, it's 11 till 10:30.
Yes. So what I'm asking of you, so if you buy a tray load of drinks at 10:30,
You will have the normal half an hour.
that's so it's actually 11 o'clock. That's the place, right? That's fine. That was the number I was after. And finally, Chair, at this particular moment, there's many talk about noise levels from both sides in all this paper I've got spread all over the place here. And they talk about restricting recorded music volumes and live music and things like that. And we talk about the noise from passing cars and all that. I'm not hearing a lot about the noise of customers. Now, what I mean by that is, I'm sure we've all been there, certainly have, where you're in a close-knit area, and some of these tables on your own plans are, well, they look relatively close together, and when people have start to drink a bit more, the noise level goes up because you're competing against the people sitting on the next table, till eventually at the end of the night, not that I'm saying your customers are all going to be alcoholics, of course, don't get me wrong, but at the end of the night, if everybody's talking louder, I suspect that might be a higher level than the music level, or possibly even the passing cars. And I'm not seeing much information, maybe I've missed it, on the noise level, and I can speak to whoever wants to. I might ask the same question in the next half as well. To the experts, if you wouldn't mind me giving me something about the noise created later on at night by the people who were there.
Could I ask you to go to the microphone, please? Sorry.
In my report and in the Apex report, we did allow for people speaking loudly. So at the later time, Apex made reference to various research that had been done about this, but they have allowed for people being loud.
I did say some references to
Yeah.
loud. I'm not so sure is what I would class as loud when you have 350 people together at the end of the night having had copious amounts of alcohol, or maybe not. Some may have, sorry.
I think, and Paul may correct me here, I think the chances of having 350 people at 10:30 having been drinking heavily all night is minimal. I think, you know,
Sorry, you discuss in your report patron noise.
yes.
Yeah. And I think you specifically say that we can address that through the way that the building and...
There are, and this will make a difference, there are the booths that you can see around the side that are more comfortable than the benches outside, and they are enclosed, and they will have some acoustic treatment within them that will absorb a certain amount of the sound. So that will be 50 or so people who will not be contributing to the noise as much as if they were sat outside shouting.
Okay, that's fine, but
Yeah.
the ones in the middle, the tables, you said yourself they've got the canopy or what on. But
Yeah.
The canopy wouldn't make a great deal of
The canopy won't
reduction.
make a great deal of difference, but I think the buildings around will make a further reduction, and I think in both our reports, that's
Okay, that's fine for
Yeah,
me.
okay.
That's fine, thank
Right.
you. Thank you very much.
Thank you. Have you got any questions at all, Alex?
I think if this came to strategic planning, I'd have a number of questions, but it's the licensing, which is completely different. So, a tentative question on public safety. You mentioned you would have security there if they close a business. How do you propose to operate that security? I'm looking at possibly, would there be a light nuisance to nearby residents?
Basically, no. Everything will be switched off and closed off. The security or our member of employment will be wandering around the site. He'll have just to the back, if you look at the plans, we've allowed an area where we deliver and everything. There'll be a cabin for him there. There's also, as I say, CCTV all around and outside. And he'll be wandering round. And we'll give him free licence to wander around the village as well. So if you know Ponteland, you know it's quite a small area, and he can wander around. You never know, he might help the police in whatever might crop up. I have to say, Ponteland isn't a high crime area, but we need him there to make sure that everything's safe through the night, because we can't lock it up properly, but there'll be no light nuisance as such.
Thank you very much. As I say, Chair, I'm repeating myself, but you can see that many of the objections by residents, a lot of these issues are planning issues, and it's difficult to distinguish, but we have to make that distinction.
Thank you. You mentioned CCTV, internally and externally.
Correct.
How many cameras externally? Roughly.
There'll be one at each corner and one in the middle.
It'll be able to monitor the whole
site,
area.
every inch will be covered.
In fact, it'll be monitored 24/7, presumably.
It will, yes.
So you tend to plan that once you've started building, 'cause then you know your sight lines, all that sort of stuff.
Great, thanks.
Yeah, sorry, there was one other question I wanted to ask at this particular time. You mentioned about toilet provision being over and above the BS standard. Now, you mentioned the 350 capacity was to do with the outside area. I want to know, when you say it's to BS standard, adequate provision, is that just for the outside area, or is that including the toilets that are in the already existing restaurant side of it as well? Yeah, please.
Yeah, so that the 350 capacity is covered by the toilets just in the outside area. So Rialto has its own existing toilets, so seen as kind of sanitary-wise covered separately, and then we've over provided toilets in the outside area, which covers that entire outside area of 350
Okay,
people.
so the provision that is above BS standard, it's just for the outside area, and it's not including any other toilets anywhere else?
No,
Thank you.
yeah.
While you're there, there's no join between Rialto's and the orchard. there's no link between the two. You either go in the orchard and out in the orchard and out of the orchard, or you go in Rialto's for a meal and out of Rialto's. There's no link between the two.
So they have, independently, they have their own entrances. So if we refer to Rialto's and the Orchard, they both have their own entrances, their own independent fire exits and toilet provision.
Yeah, so they're both separate entities, basically.
From a health and safety perspective,
Yeah.
yes. Yeah.
Right, thanks.
I've just got one question, Chair. Just talking about the differentiation between the Rialto's restaurant and the external area. Obviously, you're making differentiations in respect of licensing matters and hours of opening, things like that. I'm just wondering whereabouts, I think it would have been useful to delineate that on the plan, what you refer to as the external area. I think we all know what it is, but obviously, technically, I suppose some of these, serveries could be, it's not external.
Apologies, I thought it was, maybe it's my mistake, I thought it was obvious, but if you want me to annotate the plan in a different way, happy to do that.
What I'm essentially asking is, would you be happy for a separate line to be around that, to cover that external area?
If that makes it clearer for you, yes.
So just to be clear, the back of house deliveries area, that isn't part of the external area?
That's where,
That's
no,
part of Rialto's?
that's, well, it's a delivery area for both Rialto's and the external area.
Yeah. I was just wondering what that part was, whether it was external or classed as external or not. Okay, thank you. No further questions.
Thank you. Excuse me. Questions from the other side? One second, sir. Have you any questions to the applicants?
The simple answer is yes. However, I need to speak to Mr. Harvey Clark next to me on some of the answers that Mr. Doherty gave in relation to his report, which will take a few moments. So I wonder whether A, this would be a natural break, or B, whether you wish to hear from one or other two residents whilst I do so. I'm in your hands, Chair.
I think we'll try and get this done this way before you bring him in, if that's all right.
Chair, I wonder whether we could have just a natural break now. 5 minutes.
It is 12 o'clock.
Or maybe longer then.
Yeah. Say 20 minutes? That's suitable. Comfort break?
Yeah.
Something to eat? Okay. 20-minute break. We'll adjourn for 20 minutes. Thank you. Right, welcome back, everybody. Just to clarify, Councillor Sesford would like to ask you a question.
Yeah, just to clarify something. I mean, I think it's just a misunderstanding, but when I mentioned closing at 10:30, and you said, so therefore half an hour, and then 11 o'clock, I presume it's still 11 o'clock on a Friday and Saturday, though?
Sorry, sir. Yes. Closing of the external area, Sunday to Thursday, 11 o'clock, Friday and Saturday, 10:30.
We did just talk about 10:30 before, but I realised that obviously when I checked it was half, yeah. So basically, just to make sure we're all on the same hymn sheet here, stop serving alcohol through the week 10:30, finish at 11, and 11 and half 11 is Friday, Saturday, right? That was it? Yeah.
Thank you. Right, we'll go to, I'm sorry, I've forgotten your name. Mr. Kemp, would you like to ask any questions of the applicants, please?
I would. I wonder if I can address Mr. Doherty, with your permission, Chair, on his report, please.
Dr. Doherty.
I do apologise.
That's okay.
You work for DAX Limited, is that right?
Yes.
Are you a director?
Yes.
And I understand, and please correct me if I'm wrong, that DAX supplies sound equipment, is that right?
Yeah, we do a large range of things.
Okay.
So we supply sound equipment, we do acoustic work, we do acoustic treatment, build studios, design studios,
Could you
manufacture
I wonder whether you could
equipment.
Sorry, could you speak up?
Oh, sorry.
Closer to the mic, please.
Yeah,
if you could.
we do a lot of things. We design recording studios, we build recording studios, we do acoustic work with licensed premises, we manufacture audio equipment and we sell audio equipment.
From a commercial point of view, do you have any arrangement in place, or will there be any arrangement in place with Rialtos and those attempting to develop the orchard? Does the company have any commercial arrangement with?
No,
Anything potentially in the future?
there always is, yes, yeah. I mean, we certainly would be involved in trying to make sure that they conform with all the provisions that we're talking about here.
So, in other words, the company has a commercial so sorry, a commercial interest, as someone has just informed me, in relation to the development of the orchard. Would that be fair to say?
I'm not sure if that would be fair to say. Do you think that would be fair to say?
You'll need to answer the question, I'm afraid.
Okay. In that I may be involved in future elements of it. Yes, I guess that's true.
Would therefore, Dr. Doherty, it be fair to say therefore that your impartiality in relation to completion of the report is not complete, is it? By the very nature, you work for a company that may have a potential commercial interest in the future.
That is yes, I guess you could say that. I would disagree because the report that I made was providing information. I mean, okay.
But you understand that you are providing information as an expert to a committee for them to form a decision, and therefore your duty is to them and not your client. Do you accept that?
Yes, I do, yes.
And therefore, is that not, I'm afraid to say, a little questionable, given that you've admitted that you have a potential commercial interest?
No, I don't think so.
You kindly stated that the report by Apex Acoustics was predominantly correct. Is that right?
Yes.
Okay. I notice you don't have any paperwork in your hand. Do you have a copy of Apex's report and your
yes,
report
I do.
to hand?
Yes, it's just down there.
Would you mind retrieving both of them, it might be easier, Mr. Doherty. Thank you. Sorry, Dr. Doherty. Could I ask you, please, to turn to Apex Acoustics report at page 3. And it's paragraph 2.3 that I am interested in, where it says, an assessment of potential noise due to music and patrons has been carried out following guidance of the Institute of Acoustic Good Practice Guide on noise from placements of entertainment. Do you see that?
Yes, I do.
Your report is absent in relation to that. Can I therefore assume that reference to that guidance was not taken? Am I right?
Yes, because that guidance is to do with outdoor venues with live music, of which there was to be none.
But we'll probably come on to this later on. But do you accept that there is going to be some form of live music at the Orchard, as Mr. Arnott has already told the committee this morning?
Yes, there will be live music, but not of the nature that the Apex report looks at.
And I think, again, you candidly said that you don't possess the necessary qualifications that Jack Harvey Clark does, the author of Apex Acoustics.
I perhaps said I don't have the qualifications, not the necessary qualifications.
Right. So you say that you have a PhD in what?
Musical composition.
Okay. So what qualifications do you possess, Dr. Doherty, that gives you the foundation and the expertise to supply a report that you have done to this committee?
I thought I'd explain that. I study acoustics as part of my music degree. My PhD spent a lot of time looking at computers, the way acoustics works, and the acoustic nature of materials and spaces. And then I've spent the last 20 or more years working in acoustics.
But forgive me, your qualifications don't deal with outside entertainment areas, do they? You appear to be working inside if you're designing studios and dealing with computer acoustics. Am I right?
No.
So could you enlighten me as to how your qualifications transpose itself onto areas like
my
the Orchard?
qualifications do not directly qualify me or are not related to that directly, but my experience over many years does.
Can I ask you please to turn to page 2 of your report, if you will, please? And it's the third paragraph down from the title introduction.
Yep.
It would appear, and if I am wrong, please correct me, that what you tend to suggest is that a level around 80 decibels is somewhere that will produce inaudibility to the nearest residential premises. Am I right?
A maximum level of 80 decibels, yes.
So anything over 80 decibels is going to reach the nearest residential premises with the barrier, which again we'll come to, in place. Am I right?
No.
Well, you've just said it's a maximum of 80 decibels.
Yeah,
So if you
the sound system will be set to a maximum of 80 decibels. That is the plan.
Right, okay. Well, perhaps we'll deal with that now. As I say, you have stated, that's me, that predominantly Apex Acoustics report is correct, and the only issue which I will address again in a minute is in relation to booths and other such areas. But if you could turn to page 8 of the Apex report, please.
Yep.
So if the sound system is going to be set at a maximum of 80 decibels, if you look at paragraph 8.3,
Yep.
it's measured there that the vocal effort of one male speaker at 1 metre in front of his mouth, talking very loud,
I think, Chair, it's possibly the papers that have been picked up from outside, is it?
These are from outside, man. They're all missing. Missing pages.
I think the...
To speed things up, if you could, please.
I think, unfortunately, the way it's been printed off or
Oh,
copied,
I've
it's
got them
missed alternate pages. The Apex report that was circulated by email yesterday has got all of the pages.
do you have page 8, Dr.
Yes, I
Duffy?
do. I do.
Thank you very much.
Thank you.
And I'm referring to paragraph 8.3,
Yep.
where measurements are given in respect of a male speaking, a distance of 1 metre, taken from 1 metre in front of the male speaker. Relaxed is 54 decibels, normal 60, raised 66, loud 72, very loud 78.
Yep.
So that's one person. If the capacity, as Mr. Arnott has said, is 350, all of which are talking, and as one of the committee said, as the nights go on, voices get louder and louder, your background music somewhat gets drowned out, doesn't it?
Yes, it does. Yes.
And would you accept, therefore, that the noise from patrons is likely to exceed 80 decibels, is it not?
Yes. Yep.
And would you accept that that noise is likely to, if I use the word escape, over your 6 metre barrier to the residents nearby, is it not?
Yes, and through the barrier of the constructions there, yes. But the 80 decibel limit within the market square was never set as the loudest sound that will not transmit or be inaudible across the way.
No, I accept, Dr. Doherty, that's not a condition, but in some respect, I think you refer to it in your report as background.
Yes.
Yes. So that's background noise, so maybe some if it's family orientated, one would expect some gentle music or whatever.
Yeah.
But what I'm suggesting is that's going to be usurped quite considerably by patrons even talking, isn't it? So to hear
yes.
any background music, you're going to have to turn it up, aren't you?
No.
Why not?
No, because it's not a pub, it's not a bar. The music is literally background music. If there are people in there talking, then there's no need to turn it up because the people are there talking. It's purely to give a background. It's not to be a focus for people.
But would you agree it would seem rather pointless if you can't hear the background music to have it in any place, aren't you?
No. The background music is there for when it's not full. So that when it's not full, people will come in and it won't be empty and there'll be no sound. It's
As you are no doubt aware, the application is for live music.
that live music is included on it.
Yes.
Yes.
Would you accept that in your report you've not really dealt with live music at all, have you?
No.
It seems to be absent.
Yes, it is absent because I don't think that it's going to be a significant contributor to the noise.
Okay, all right. Well, we've heard this morning that it's going to be, I think I'll use Mr. Onnott's phrase, and if I'm wrong, I'm sure I'll be corrected, duets.
The maximum
Or-
duets or solo artists, yes.
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 So one would expect them to be playing some form of instrument,
Possibly
not the
guitar.
drums,
Yeah, not the
but
drums.
even maybe classical instruments, violins, flutes, oboes, etc. Would that be fair?
More likely to be guitars, I would say.
Okay. Well,
Acoustic guitars.
Well, let's assume that there is an injection of culture into the orchard and people come on and play classical instruments. Are you aware of the decibel output of classical musicians or instruments which was and has been put out in what's called ISO 23591? Are you aware of that?
I'm aware of the levels of classical instruments, yes.
So would you accept a violin is 81 decibels,
Yes. Yeah.
flute 83,
Yeah, I can imagine that would be, yes.
oboe
yes.
85, and you say guitar, that's at 81. Would you accept that?
I would not object to that, no.
So, given the fact that that is a live band, again, that's going to be simply drowned out by patrons talking, isn't it?
If they're not listening, yes.
So they're going to have to be turned up, are they not, for anyone to hear it?
No, they're not, no. Mr. Holliday has already mentioned that. They can't be turned up because there's nothing that they can be turned up with.
All of your calculations with regards to sound appear to be predicated on the erection of a 6 metre, I use the word barrier,
Yeah.
fence or whatever phrase you wish to put it, that runs in some sort of almost a semicircle round the eastern and southern side, is that right?
Yes, that's correct, yeah.
Where did you get 6 metres from?
I think actually, just let me. I think that. I think that the figures that I used were 5 metres. Yes, 5 metres.
5 metres?
Yes.
Sorry, could you point that out in your report, please? Have
Yeah.
I
Oh,
misinterpreted?
sorry.
Could
Yes.
you speak closer to the microphone?
I'm sorry.
Louder?
I'm sorry.
Is that
I'm
at
trying to
page
face
4,
over there and.
calculations of reduction?
Yes.
Okay. And what would the fence have to be constructed of?
It would have to be constructed of something solid, probably 25mm plywood, something of that nature.
Okay. So would you accept that's some height, isn't it?
Yes.
I mean, as an analogy, the Berlin Wall was between 3.5 and 4 metres,
I
and
was unaware
prison
of that.
fences are 5 metres. That's a behemoth of a fence, isn't it?
This is the height of the fence that I was given to work with.
By whom?
With respect, that's really not a licensing thing. It is sound-wise, but this would have to go through planning as well. So
Yes.
if it was to be approved here, then it's still got to jump through the hoop of planning.
Yes.
So that may knock it on the head straight away, if it is approved.
But of course, if you don't have that fence, the sound escape from the orchard is going to increase, by analogy, is it not?
Yes, it is, yes.
Yes. And in fact, that fence doesn't stop all sound escaping, does it?
No.
No. And therefore, when you said this morning that you considered an error, I use the word error in a loose sense of the phrase, however adjective you wish to put on it, with regards to Apex Acoustics' report, that they haven't considered the booths and I think
Yep,
the
the
servery.
buildings which form an additional barrier.
Yes.
Yep.
But of course, if sound's escaping, it's going up and over the fence, and therefore the booths will actually have no effect whatsoever, will they? Because the booths aren't going to be 5 metres tall, are they?
No.
No.
But they will be in the flight path of the sound, so to speak.
But their effect, would you not agree, is going to be absolutely minimal?
Yeah.
Sorry.
I've stated that in my report.
Dr. Doherty, you also make reference in your report that you have, I think it's at page 7, made reference to...
PPG 24?
Yes.
Yes.
You now accept that that's wrong, it's outdated.
It is an outdated standard. I was merely referring to the fact that the WHO and the PPG 24 talked about the same kind of level as an acceptable level.
Would you just forgive me just a second? Would you accept that PPG 24 is to do with transportation and not entertainment? There's a different type of noise in that guidance, is it not?
If it's, well, PPG 24, in my understanding, was to do with the noise of roads and nearby noise relative to new residential developments. Is that correct?
So it is to do with road noise and not from entertainment.
Yes.
Yes.
But nevertheless, it still gives that same figure, background noise figure, for acceptable levels.
So, given the fact we have 350 patrons attending the orchard, given the fact, as I've said, with regards to the decibel noise, both of live music, background music, and speaking, would you now accept that the premise upon which you state that the premises will not cause any nuisance to nearby residents actually doesn't stand up now, does it?
Yes, it does, yes.
Sorry, but we're labouring on the noise
finished.
thing,
Yeah.
basically.
Yeah.
But there's a condition, if it is approved, there's a condition number 19, if you look at that, which says noise from amplified live and recorded music arising from regulated entertainment heard within a designated premises shall be inaudible at the boundary of the nearest residential dwelling.
Yes?
So surely that would cover any noise. If there was more noise than that, if it was heard at a nearest residential dwelling, then that would be against the condition and could be followed up.
Yes, well, this is part of the submission that we're going to be saying that that condition, whether you have it or not, doesn't stack up with regards to what is being recommended. Because, with the greatest of respect, Chair, you're coming to that conclusion without hearing from Apex yet.
That would be up to the applicant to make sure that doesn't happen. If that does happen, there's a condition here which will stop it all.
Yes, but then you get to the point of what is a definition of inaudible, and that's already been dictated by the appellate courts as being unenforceable, because it's subjective. But that's a matter of submission, and no doubt you'll be advised on that. But I've finished with Dr. Doherty, if that's the point that you're making. Whether others have questions for him, that's a matter for them in their submission. But I was going to now direct some questions to Mr. Arnott.
Thank you. Lovely.
Before Mr. Doherty leaves the microphone, can I ask one question of him for clarification? I know it's a bit sort of backwards and forwards. Take 2 seconds.
Right.
Dr. Doherty, in sort of acoustic circles, is it not accepted that when you have a group of people together, if you've got 2 people together, one is talking, one is listening. If you have 4 people together, one is talking, 4 are listening. It would never be the case that all of those individuals will all be talking at the same time.
No, it wouldn't be.
Right, would you like to ask your questions?
Mr. Arnott, I wonder if you could turn to page 270, which is Mr. Walton's objection. I wonder whether you can confirm my understanding of what you said this morning, that this variation of a licence in relation to Rialto's restaurant has now been withdrawn, so there's no application to add off sales, etc. Am I right or wrong?
You're right.
So that no longer exists.
The application that we have before us today is for a new licence for the entire premises. The variation application, which was made by my client, was withdrawn because objectors said that the extent of the variation was inappropriate for the variation process.
I think they still aren't adding off sales because there was a variation application and then this is a replacement licence that has off sales.
If you have a question, would you like to ask the question yourself?
Yeah, when the time comes.
Yeah, when the time comes.
I don't have a question. I'm just trying to be helpful because I know I was criticised for referring, how dare I, to an earlier variation application that was withdrawn.
Can we just have one of your questions first, and then when you ask your question later?
I think Mr. Kemp, my learned friend, and Mr. Arnott are talking at cross purposes, so I'm just trying to assist. But if you don't want me to, I'll shut up.
Just for clarification, no, please. Thank you.
Right. As I understand it, the existing premises licence for Rialto's restaurant
Daughter
doesn't...
said no.
Oh, that was a no. Sorry.
I'm sorry. I'm conscious this is turning into a court scene. Really, it isn't a court. It's a panel, and we've got so many solicitors here. It's getting a little bit over the top. So if we could just ask questions, straight questions, not technical ones,
Sorry,
we'd all
sir,
appreciate
we
it.
can't help ourselves.
I know it's your jobs, but I'm trying to save the client's money. So would you like to ask your question of Mr. Arnott?
Thank you very much. Given the figures that you have stated this morning, you're still going to have in excess of between 150 and 200 vertical drinkers in the orchard, given your seating plan. That's right, isn't it?
We have a potential total capacity of 350, and I think, as Paul said, it's highly unlikely that we would ever trade at that number, but that's the potential maximum capacity. Yes, we have seats for 152, so other people will be milling around. Yes, that's right.
And it's fair to say that though you say it's family orientated, ultimately at 9:30, 10 o'clock, it is likely that the only people that will be attending will be those wanting to consume alcohol. That's fair, isn't it?
No, I disagree.
So you expect families with children to attend Rialto or the Orchard at 9:30 to buy artisan bread? Is that what you're saying?
There will be all sorts of things going on, and it is not the case that you could have older families. It will be a family venue predominantly, particularly during the day and into the evening. It will not be the case that the families will disappear at 6 o'clock or whatever time and be replaced by 25-year-olds who want to get drunk.
But that's an assumption on your part, is it not?
You've made an assumption, surely, in your question to me.
Yes, but it's you that's applying for the licence, is it not, Mr. Arnott? Yes, thank you. That's all the questions I have.
Are there any other questions from other solicitors, barristers?
Chair, I've got some questions, but I appreciate that I represent a trade objector, and I don't want to sort of elbow my way in front of residents. If there are any residents who want to go before me, I'm happy to hang back. But if you'd like me to crack on, I will do so.
Are there any residents with any questions to Mr. Arnott? Yes, sir, if you come to the mic and what's your name?
My name is Alan Atkinson. I'm a resident of Ponteland. One question. You stated... Atkinson, yes, Alan Atkinson. You stated in your as you gave your spiel that everything would be finished serving in the orchard at 10:30. Is that correct?
If you refer to the application, you will see that the activities that we're asking a licence for will finish at different times. So, for instance, if you bear with me, recorded music externally would finish at 10:30 Monday to Sunday. Live music, such as it will be, will finish at 8:30 Monday to Thursday, 9:30 Friday, Saturday, Sunday, and on bank holidays. And the sale of alcohol will finish externally Sunday to Thursday. Sorry, I beg your pardon. That's we will open to the public. We will close the external area Sunday to Thursday, 11 o'clock, Friday and Saturday, 11:30.
But you state on your plans on page 8 of the document named The Orchard, and I'm looking at page 8,
Yep.
in the top right-hand corner, the red line indicates areas where A, alcohol is sold, B, registered entertainment will take place, C...
Sorry, what document are you looking at? I'm looking at page 8 of the main bundle.
document named The Orchard,
Oh, sorry, I beg your pardon.
page 8.
Yep.
Yeah?
Yep.
Top right-hand corner. The red line indicates the area where A, alcohol is sold, B, regulated entertainment will take place, C, hot food or drink after 11 p.m. will be supplied.
Yep.
So is it being sold after 11 p.m.
No,
even if it's being supplied,
No,
or is it not being sold? The two do not go together.
Right. The drink that is referred to there is what we call late night refreshment, which is hot. If you sell hot food or hot drink after 11 o'clock at night, you need that as a permission. That which is referred to in that particular section that you just quoted to me is not alcohol.
So the licence is definitely going to stop anything being sold after 11 p.m. And I'm asking this of the chair.
It is as we've applied for. 11 p.m. that is referred to there is late night refreshment, which is not alcohol. It's something entirely separate. It's hot food or hot drink.
Sorry
a
about
hot
that.
cup of coffee after 11 o'clock, we need a thing called late night refreshment, a specific permission.
No further questions, Chair.
Thank you. Anyone else? No questions of Mr. Arnott? The floor's all yours, seemingly.
Well, if I could ask some on behalf of my client. Firstly, just in relation to the transparency that was said to be given in this application. The application itself has a description of what's provided at page 20 of the bundle. And we can see that in relation to the external area, there's a single sentence: the external area shall provide facilities for the consumption of alcohol, entertainment and food. The note wasn't provided until the end of the consultation period. Is there any reason why the note wasn't provided at the beginning so the public could understand what was provided here? Because one sentence is hardly adequate, is it?
None whatsoever, but in terms of the application itself, what we intended to convey there was the licensable activities that would be provided by the licence if it was granted. We weren't giving a description, a general description of what it is that we proposed. And the note that we provided was provided actually at the suggestion of your licensing officers, because they became aware of what was being said about our application and that a lot of what was floating around simply wasn't correct. It may well be that tactically, if we'd started again, we'd have submitted that that description with the application itself. But obviously at that point, we weren't aware of what people were saying about our application.
So the first time anyone knew about a capacity limit in relation to the park of 350 was when they saw the note at the end of the consultation period.
I think we'd already given that promise to the town council, had we not, when we had our meeting. So that was not a new thing.
Right, but you didn't tell anybody else. It wasn't in the public consultation. The public or my client or Mr. Grunet's client, because I know he's been criticised about this, couldn't have known that you had a capacity limit of 350 proposed until the note came out.
As I understand it, and I'm being told that we have always talked about a capacity of 350, certainly never 1,000 or 800, always 350.
And let's just be clear about this. The 350 capacity gives you the potential to have 198 vertical drinkers if the balance choose to take the seats, although they don't have to.
We're confident that that will not happen, but yes, it may happen, but it won't.
Could I just ask a couple of questions about the acoustic fence? When was that incorporated into the scheme? Because it's not on the original plans as part of the application.
That's probably a question best answered by Paul.
The acoustic fence propped up in consultation really with, he's gone. There was one of the objectors here we spoke to who lives directly across the road. And one of his objections, which we quite agreed with, when creating an orchard, we wanted to have something totally new. So Steve and Val, who live in the White House, which is directly across the road, not near Mr. Walton's, who is 110 metres away, by the way, but we were very aware of what it would look like from his window. Irrelevant of noise, he wasn't bothered so much about noise. And we just thought, as something very new, in conjunction with our architect, we will put a 6-metre fence. That fence will have on one side screen printed an orchard, and on the other side we're putting a wall of flowers. It's quite a new idea, it's been done in London. The flowers will go through to the other side and drape down, so it'll look like a green wall, a wall of vegetation with flowers and everything else. That's where that came from.
The route of the fence, am I right in thinking, if we look at the latest plan, page 8 of your brochure, Mr. Arnott, am I right in thinking that it's sort of an inverted C shape? It doesn't go around the whole site, so it starts at the car park on the west, goes down around and back up in between the refuse deliveries area and the units there. Is that the location of the fence?
That's correct, yes.
It's about 100 metres long, I would estimate. Is that fair enough?
Sorry? we can't confirm that, but I wouldn't dispute that.
Yeah. And just about heights, because Dr. Doherty said 5 metres, but Mr. Diamond's just said 6 metres, and it's 20 foot in your brochure, which is 6.1 metres. Is it 6 metres or 5 metres? 6.1 metre fences. Now, living walls, which is what you've just described, are incredibly expensive. And acoustic fences don't come cheap, and one that's 6 metres high is going to need piled foundations, I would imagine, so it doesn't blow over. How much is this thing going to cost? Have you budgeted for it?
Yes, and it's irrelevant, I think.
Well, it is rather relevant, isn't it? Because you're spending a lot of money, and you're going to have to need to make that back by selling alcohol. So it is rather, because it seems, and I'm just guessing, but hundreds of thousands of pounds on this fence, surely.
It's not, that isn't really, the value of things isn't relevant at all regarding licensing. And in a way, one moment. In a way, I can't understand why everybody's going on about this fence, when, in a way, yes, it has got something to do with acoustics, but it's still got to be approved by planning. If this is approved, it's still got to be approved by planning. So I don't know why we're labouring on this point.
Well, Chair, with respect, I think something of this, an object of this mass on this site is relevant. And I'm just going to, if you be patient with me, I've just got 2 more questions.
It is relevant, but it'll be relevant at planning. They'll be the ones who decide. It could make or break this, totally.
I'm going to suggest it's relevant for licensing for the following reason. Do you accept that without this 6 metre high acoustic fence, the site is unworkable given its proximity to residential?
I don't accept that, no.
Well, why have you come up with it? Because nobody would do this for fun, would they? So if I was to suggest that if this licence is granted, it be a condition, that the condition be opposed to prevent public nuisance, that there be a 6 metre high acoustic fence running that route, you wouldn't agree to that, Mr. Holliday, is that right?
Discuss it with the planners. We just discuss it with the planners.
So far as you're concerned, it's not a licensing issue at all. Your noise expert has come along with a report saying, I'm relying on a fence. He gets the height wrong, but I'm relying on this fence as part of my calculations. But your position is it's completely irrelevant to this committee to take any regard to that. Don't you slightly want to have your cake and eat it there?
Possibly, yes.
Yeah. Altrincham Market, when did that become your inspiration? Because the initial plans had 2 bars and a stall for ices and a stall for teas. When did Altrincham Market come into play?
I went down and met the owners of Altrincham Market.
When?
Oh, probably April, before, probably March of this year when we first came up with the ideas. And we discussed the value of what it cost them to do what they've done. And they've also done it in Macclesfield, by the way, and they've created such a wonderful setting.
Because the first time we see a plan that has any form of market was last week.
No, we've always had that. The original plan we put in with the variation was all we thought, with discussions with the licensing officers, that we needed to do at the time.
Have you got the short bundle of documents that I submitted that shows the plan that you put in with the original plan with the variation?
I will have, yeah.
Could you have a look at it, please?
Mm-hmm.
I just interject, sorry, just for the members, it's the document entitled on the front, Danieli Holdings Limited Bundle of Documents. Has everyone got that? Chair, do you want my copy?
And you've
Do you
gone
want this?
through,
It's-
you're on to your third architect now, Mr. Holliday, but the first one you had, Mr. Cook.
We're on to a second architect.
Well, you had Mr. Cook, and then you had PJC Architecture, and now you've got...
Mr. Cook was the original plans of the building. He didn't actually draw it.
Now you've got collaborative
Yeah.
design.
Correct.
So the first plan, which was created after you say you'd been to see Altrincham Market, can I respectfully suggest that doesn't show a market at all? It shows two little bars
Quite right.
and a tea
Yep.
stall and an ices store.
Yep.
It's something very different from what's being proposed
Yeah.
now.
Is it really a relevant question? Because that was an original plan. We're looking now at
I will
what
come
is in
back to
front of
this in
us.
my closing submissions, Chair. The Altrincham Market, that's a market at law, isn't it? It's a legal market, a concourse of buyers and sellers, where the market franchise is owned by the local authority.
No, it's owned by the men
The
themselves.
franchise is different from the real property. So the
Yeah,
market
it's not a franchise.
No, a market franchise, it's a 12th century market franchise, and it's owned by Trafford Council, and Trafford Council invested nearly £1 million in its regeneration as part of a regeneration project by the local authority. It's completely different from what you're offering here. This is a purely private enterprise by you and your business partner, isn't it?
It is, yes. It's the money we're willing to invest on the same scale for our community.
I mean, you've had no liaison with the local authority in terms of providing what would be strictly defined as a market at law, have you?
No.
I don't think it's a relevant question, I'm sorry.
Well, again, I will come back to it in my closing submissions. The layout of the shown on the plan, we've got various units providing retail, food, cellarage, bars and the rest. Those units, are they going to be fabricated out of shipping containers?
No.
Are they of the size of shipping containers? Because they are rectangular in shape. Have you taken a sort of shipping container as the template for the size of these particular units? I mean, I'm asking, for instance, they look quite... my client has lots of experience of operating box parks, and it's normally quite tight to have a unit in a single 40-foot high cube shipping container. You look to be splitting them into two. There aren't any storage provisions. There's no back of house for any of the catering. There's a line of what look like to be shipping containers that you've divided up. Have you... Are you providing sufficient space for these food and retail users here?
Yeah, so if you refer to both end flanks, we've got cellar and storage
Yeah.
at both end.
I mean, could you
And then
just give me a hint, sir, how long is the cellar, for instance, and I can then kind of work it out from then. I mean, a shipping container is about 12 metres long. Is that the sort of unit you're working on here?
Can I ask what your relevance to the question is?
No, I just want to know how... I wouldn't have thought it was a secret. When it is said, for instance, that there's going to be Thai street food, retail florists, how large those units actually are. The relevance is the genuineness or otherwise of your paymaster's intention and the workability of the site.
I would estimate the food retailers to be...
Could you speak to the microphone, please?
I would estimate the food retailers to be about 12 metres by 2.5 metres.
So
Sorry, probably closer to 9 metres by 2.5 metres.
that's, say, the retail artisan baker, for instance, that would be 12.
The retail artisan baker is larger, so that's probably about 12 metres long.
Yeah. So about the size of a shipping container, basically.
Well, I can tell you that those are made from hardwood, and they are to replicate the Victorian street.
Am I right that the only storage on site is provided on the first floor of the eastern block?
Yeah, that's the only dedicated storage, but there's also cellar storage at both ends of the operation.
I mean, my client, in operating the Stack franchise as it does, one of the major issues it has on its site is that tenants, people operating food units, have a sort of insatiable desire or for storage space. If you're selling coffees, for instance, you need a lot of space to store cups and lids and things like that. It sounds trivial. There doesn't appear to be any storage at all other than that central area for your food and retail users.
Yeah, well, as I've already mentioned, the storage is there. From my 30 years experience, the more storage you give people, the more they'll use.
Yeah.
So I can tell you that this is worked out predominantly to allow storage for those people that are using those units.
In your 30 years experience, have you ever designed a box park or an outdoor or mixed use area like this, or is this your first?
Many.
Can you give me an example?
An example of
One
we've
you've
done.
designed in the past? Because it seems your designs are rather different from the ones my client operates to.
Yeah, so we've recently done the urban garden in the quayside.
Again, is this relevant for a licensing hearing? To
I'm
discover what
going
was done in the past?
I'm going to move on. Condition 11 of the conditions offered refers to individual bespoke events. Is the operator got in mind what bespoke events it's going to provide? Chair's totally against us, isn't he? Yeah, all right.
Yeah, I mean, basically what we're going to offer is what you would have had at a Victorian market. So you'll have face painters, you'll have street artists, you'll have people wandering around, a magician. Very simple entertainment that would probably entertain children whilst the parents shop at the market stalls. And various things like that. Nothing to do with alcohol as such, but the entertainment of a family.
Yeah, those are roaming entertainment events within a normal trading day, aren't they?
They are.
Yeah, I'm asking, are you going to have any occasions where the whole site hosts an event, is given over to a different event?
We've not thought about that unless somebody books it.
Well, your concept document talks about Christmas fairs.
Yeah, well, yeah.
for instance.
Sorry,
So
I thought you meant like
unless-
weddings and stuff like
Unless
that.
your concept document is
No.
something you haven't read, you have thought about it because it's in your concept document.
We will be doing farmers markets, Christmas markets, summer fairs, everything that you would. I keep saying Victorian, but if you go back to that style, one of the beautiful things about Richmond is they stopped their whole market square having multinational companies, a bit like Daniela Holdings, coming in and taking over. Okay? All they allow is individual members to come in that have, say you sell honey, you sell candles, the butcher is a butcher, the baker's a baker, but they're all local people.
Now,
That's our offering, and that will go on into the night as well.
now, if you're granted this licence, cast your mind forward to next year when there's a major international sporting event on, the World Cup, and matches are being played, and lots of people want to go out and watch those matches in the company of like-minded individuals and consume alcohol when they do so, and not particularly eat much food. That's going to be a facility that surely you're going to want to offer to your clientele and your customers.
We'll judge that when it arrives. We
So
haven't
you-
thought that far ahead.
Well,
We're
you
thought
surely
along
must
the
think.
stage of the
I mean,
Victorian market.
You must. So you haven't contemplated yet whether you're going to have live sports
No.
shown up, because I thought Mr. Arnott said you
Initially,
weren't,
we're not.
and that seemed to me quite surprising, because that's for an operator flushing money down the toilet or barring money at the door.
We're hoping what we're offering is not the conventional.
Well, so offering live sport, for which you don't need any particular licence, you don't need a film licence. I know Mr. Arnott mentioned that is certainly a possibility at this site. You could have 350 people watching a football match and cheering on.
We haven't thought about that yet. We're only trying to get the concept that we're doing off the ground.
Yeah, certainly in the hospitality sector at the minute, people are getting very inventive to get the footfall in, and certainly in Newcastle there's a trend to have bingo nights, for instance, bongo bingo, very popular at the.
That's a drinking game, by the way.
Sorry, it's a big earner, I understand, at the Boiler House, and the Jesmond Beach Club has things like that. Are you going to recoup your investment? Are you going to market those sorts?
Surely
of
that's a chance we
arrangements?
take.
It's a chance.
It's our money.
Yes.
We're investing our money in the village. If it works, it works.
Yes. So if you get the license, it's a chance that the residents take that you're going to have that, yeah, or not. That's a gamble for them.
As I've said before, when we get to planning, we will have a full open house, and people on a particular day, 2 days, they'll be able to come in and see exactly the setup. They'll have a walkthrough, a visual walk through the thing. They'll be able to see everything we're doing.
You're going to consult on this after you've made the licensing application. That's the plan.
It's what comes first, the chicken or the egg.
Exactly.
This happens to be the licensing.
Could I?
After this, there'll be planning. So the hoops have to be jumped through, whichever way you do it first.
Condition 17, stewards will be in place to manage any points where road access meets foot traffic to ensure both can pass without incident or collision. Can I just understand how that condition is going to work? What are the stewards going to be provided every day?
Yes.
And what time are they going to come on?
Well, you'll have your own night man that'll be there probably till 7 o'clock. And then we shall be opening for coffee at around 8:30, 9 o'clock. And there'll be a full complement of staff from then till 11 o'clock.
So you're going to have a steward managing access from 8:30 a.m. until closing every day?
There'll be the meet and greet people, yes.
Well, the meet and greet people, as I understood it from Mr. Arnott, are they're the SIA registered supervisor that's clicking people in and out, and they're standing at the archway, which is the only entrance to the property. That's a different person, isn't it?
It is.
From a steward who's managing points where road access meets foot traffic.
Mm-hmm.
So there's surely, to comply with condition 17, you're going to need a separate individual from the SIA registered meet and greeter who's on the premises.
Yes.
So you're going to employ somebody or a team of people, because obviously, will that person be there all the time?
There'll be a member of staff. They'll all be trained.
And I mean, where if we look, I've put in my bundle some pictures of what from Google Street View of what the site looks like, because it's always handy to have a visual photo. Do you have that to hand, Mr. Holliday?
I don't know. Yeah.
So there's a picture of the entrance, the access route entrance. And you can see there's the signature.
Where the England crosses.
Yeah, exactly. Where the Union crosses, and there's a cash point on the other side. That's the sole vehicular access into the premises.
Yes.
So you've got cars coming in with customers.
Yeah.
You've got your delivery vehicles arriving with barrels of beer and all the
Deliveries
rest.
have got a certain arrival time.
When's that?
It's in the brochure somewhere.
Right.
I think it's between 8 and 10, if memory serves,
In the morning.
in the morning, yeah. As you do expect, as a business like this, it will be set up professionally. We own, or Sonny owns, the land all the way around. The only building they don't own on the main street is the estate agent and the post box. But they own all the land round the back. So the entrance next to the stars, and this entrance they own the land there with the cross on. So they actually own all that property. So
Well,
it makes it easy for us, we're not crossing any boundaries,
yeah.
to have the road going behind, to take all the traffic off the front street, and as you'll know yourself, and I've got pictures on my phone if you'd like to see them, one of the big problems with YOLOs that we've found is deliveries, taxis, being so close to the lights and having the diamond. When Neil did YOLOs, I was asked not to object, but that's another story. When Neil did YOLOs, I said at the time that'll be the problem because they stopped so close to the lights. Now, there was a delivery yesterday that blocked the traffic going north and south
This
for a
is
full
Yo-
10
YOLOs,
minutes.
is it? This is, you're talking about my client's premises?
Yes.
Yeah.
YOLOs.
Can we drag this back to your premises and this application,
Right, yeah.
Mr. Holiday?
I'm only pointing out that we're
Yeah, I know. Well,
alleviating that
you had
problem.
problems with YOLOs,
Gentlemen,
didn't you?
gentlemen,
I think
it's a question and answer, not an argument.
just looking at the photo with the Union Cross, this is the pedestrian and vehicular route in.
It is,
So
yeah.
you've got your customers in cars, your customers in taxis, if taxis choose to use the drop-off point.
Mm-hmm.
They may just think that's too much trouble and drop on the main road. Your deliveries coming in, your refuse coming in and out, and pedestrians.
Yeah.
And where's the steward going to stand?
He'll be on the entrance to, if you look on the plan, where it says meet and greet.
Right, so you're going to comply with condition 17, traffic marshal, by having the steward not standing where there is conflict with pedestrians and vehicles, but right back on the trading side.
He'll be wandering round on our land, yes. And
Have you
again,
done any
traffic, we are
market-
having a traffic survey done, by the way, for planning.
Have you done any market research, any formal market research in relation to this to see where your clientele are going to come from?
No. We're trusting the customers that we've already served in the village to support
So-
us again.
When it is said in your note that the majority of our patrons will be locals and will arrive by foot, the evidential basis for that is your trust.
Correct.
Trust.
Over 40 years serving the village with alcohol and the smithy in relation to all the smithy's done, the bedrooms. We've built up a wonderful client base. The village is a wonderful place and supported myself and Sonny for 40 years. And we feel we're giving a little bit back doing this and going to make it a rather special place.
So by trust, you mean trust in your own predictive ability?
Yeah. I wouldn't be here if I didn't.
I think I'm going to leave it. Do you want to take it? That's...
Thank you.
While you're standing there, if you don't mind,
Not at all.
I appreciate, Chair, that we've had a lot of questions, so I'm going to keep these brief, but don't take that as a lack of interest in the
That would be
application.
very appreciative, because it's now,
Absolutely.
it's now 1:30. We haven't had a lunch break yet as well, so...
I appreciate, Chair. I shouldn't keep you more than 10 minutes, I'm hoping. Just, Mr Halliday, Mr Holland, you've talked about your experience in the town, and you're basing a number of assumptions on that, based on your own experience. Does that include your instructions to your noise expert regarding the number of people that would be in the venue in the late time of night? The 130 with 20 loud. Is that based simply on experience and not market research again?
No, we gave, and I'll clear something up, there is no connection between Douglas and myself. Douglas was recommended to us by somebody who's done a similar scheme and came very highly recommended. I didn't realise until just now that Douglas actually sold the stuff, so we've not consulted him in any way, shape or form other than his report. His report was all we asked for, was all we paid for.
Well, thank you, Mr Halliday. Maybe a question for Dr Doherty then about that, where he got that figure from. Dr Doherty, can I ask you briefly a couple of questions? I hope these are fresh airs. I'm not going to go across old ground again. And it's in relation to your report, sir. At page 6, you have your assumptions based on certain levels of occupancy. And people have asked you about that. I know that the councillors were interested in that to a degree, and Mr Kemp took you through that for a time. But these numbers, based on these numbers, your conclusion was that the project wouldn't be causing a noise nuisance. Yes. Could you, Mr Halliday's just said that he's not the person that gave you that figure of 130 in the later evening. Where did you get that figure from?
I can't remember exactly where I got it from. I think I may have mentioned it to Mr Halliday. Said, did that seem like a realistic number of people that would be there at that time of night?
So you kind of you don't have the relevant experience to make those. You need instructions, and is that what you're saying?
Well, I have experience of working with licensed premises and the nature of this particular licensed premises, and that was my guess that that would be the kind of quantity of people who would still be there.
Okay. Well, Mr Arnott has offered a condition to the committee in his presentation of 350 people, and then everybody else, including Mr Arnott, stood up and said, but we'll never get to that figure. So it's a sort of a pointless condition because we're never getting there. But what number do we need to get to in the late evening to cause an issue? I presume it's less than 350 by a margin.
I couldn't give you a figure.
Okay. But more people are going to cause more noise, and that's going to cause an issue.
Yes, the amount of increase that you get it's not linear. So if you have, say you have 100 people and then you have 150 people, that's not going to cause you a massive increase.
No. But 350 people watching England disappoint us again in Qatar in 2022, that could definitely cause an issue.
If that was going to happen, then it might cause an issue, yes.
Absolutely. The numbers that we've prepared are 350, and what you're saying to the committee is if we have 350 persons, that will cause an issue.
It's been said that there's going to be no football, television, anything like that. So
I'm going to come to that with Mr Arnott actually in a moment. You're gazumping me again, Chair. We're on the same level here, but I'll come to that question. But just to be clear, Dr. Doherty, because I don't want to cut you off there. I'd like you to give a clear answer on that question.
Yeah.
The capacity proposed 350. If we had 350 people in there in the end of an evening, that would be causing a noise nuisance to the local area.
If they were watching a football match and shouting, yes.
Okay. But only in that circumstance, no other circumstance? Is that your expert opinion? They could only do it watching football?
I have no opinion on
Okay. Thank you very much, Dr.
Thank
O'Leary.
you.
Thank you for your time. Mr. Arnott, just a couple of points of clarification. Obviously, some confusion, I think, and this will hopefully give you the opportunity to clarify for the committee. The chair, I think, went to the first one there, and then Mr. Halliday maybe muddied the water for myself and my client. Are you saying, are you offering a condition that live sport will not be shown at the venue or not? Because you seem to be making a statement in positive.
My understanding is that that was not something that we would do, but we're not prepared to offer that as a condition.
Okay.
The condition that we have offered, though, which is very relevant, of course, is that no audibility. So no matter what we do, no audibility.
Yeah, very good.
the no audibility condition.
Thank you. And
That just relates to entertainment.
yeah, so, yeah, I'm going to get that. Yeah,
It's just entertainment.
I appreciate it. So now, a great deal of respect, Richard, but I'm not suggesting you stumbled, but you talked about football then film, but obviously film as a regulated activity has nothing to do with live sport, does it?
Christopher, it wasn't a stumble. I do know the difference. But we will not be showing films, because we don't have
Yes.
that as an activity. And yes, I agree with you that live football doesn't require films as an activity. Yes.
So the fact that it's missing from your licence, it's yes, two distinct matters. Thank you for that. The options for the committee, in summing up at the end, are to grant the applications you seek, consider whether any hurdles can be overcome by condition, or refuse the application. So obviously the conditions that you've proposed are very important. What is your view as a lawyer, and it's a legal point, I don't want to spend much time, but I think it is important. Your entertainment in the form of recorded and live music is concluding before 11 p.m. This is a premises for which alcohol can be sold for consumption on the premises. So by definition, live and recording music up to 11 p.m. is not regulated by this committee, is not a regulated activity. So when you offer a condition, and it's, I just want your view on this, that condition cannot bite your client at all regarding externals because it relates to regulated activity. So that condition, perhaps let's say not your client, but a subsequent operator could simply say, well, that condition doesn't apply and doesn't bite me at all.
That's not my view. My view is that if you've applied for entertainment live or recorded as an activity, it then becomes subject to a condition. So that condition would be applicable, that would live with the licence, and it would live with the licence no matter who operated the premises. So I don't agree with, I think, the premise you're making.
So the number of persons being less than 500 you think is irrelevant, even though that is by definition not a regulated activity?
Yeah, entirely, yeah.
Okay, yeah, I'm sure you'll come to that in your summing up because I'm still a little bit confused on that point. It's not a regulated activity. You can't condition it. So all of your conditions about audibility doesn't apply because it finishes before 11 p.m. according to you.
We've applied for it as a regulated activity, and therefore you can attach a condition.
Right, okay. You can look forward to that in our summing ups about whether that is the legal interpretation or not, and your solicitor will thank me for that a great deal, I'm sure. I think they're all the questions. I know my colleagues and the rest have covered a lot of them, so we'll rest at that point. Thank you.
Paul Gibbs, One Lowhoff. I also have the 7 stars. My daughter's here as well. It's just about the deregulation. The terms of the proposed external licensed area. The application seeks to permit sale of alcohol, provision of live music, recorded music, late night refreshment, and in a very large external area. I noted that for the live music, recorded music, late night refreshment, the box on the application where the details are provided, for example, but not exclusively,
whether or not music will be amplified or unamplified, that nothing is stated, and therefore I feel the application is deficient in that. The committee should be aware that any area licensed for the sale of alcohol automatically obtains the benefit of a deregulation whereby live and or recorded music can be provided within until 2300, as long as the audience does not exceed 500. This means that any assurances provided by the application that live or recorded music will cease earlier than 2300 are not legally binding. So I would request that the external area is not licensed. And I would also like to put in a little
Sorry, can you just-
character.
There's got to be, it's time for questions to the...
Where is the question?
That was the question. It wasn't a question, it was a statement.
This is question time, though.
This is questions to the applicant only. The interested parties, residents, the other interested parties
Well,
will...
it was to the solicitor, actually.
You'll get your chance to make your representation in due course. If you have a question for the applicant, now is the time to ask it, but it has to be a question, not a statement.
Right, as I said before, the lady on your right, you put your hand up before to speak. A question? If you got the mic.
Statement.
Sorry? Statement.
Statement.
That's for later, I'm afraid. Town Council?
Yes.
Questions?
A question, yes.
Right, no, it's there.
It's on automatically, is it? We are concerned as a... Sorry. Thought that job. We're concerned as a town council because this is not Altrincham, it's not Richmond. This is a large village. Some say a small town. But, you know, we're concerned that there might not be, in fact, there wouldn't be, the passing traffic.
Question.
And we just wonder what would be the plan should this fail. You know, as a town council, we're encouraging local businesses. We try to support local businesses, but we want to know what would be the plan should this fail, because, you know, it would then have a licence for 350 people. You know, would they all turn in? What would be the plan afterwards?
Sorry, it is very similar to Altrincham. Actually, I've got friends who live in Altrincham, and
So do I.
I've been there many times, and to Altrincham Market.
So have I.
Yeah, and we are confident that it won't fail.
What if it did?
It won't.
So, at the moment, you've got seating for about 120 people.
I explained 152.
Sorry, 152. Sorry, I've written that down wrong. Well, I've not got my notes. If at the moment then you're talking about a lot of people milling around, buying ice creams, looking at jewellery stalls and cake shops and everything, there's a lot of capacity there for people milling. Should it not work out, you know, and a year down the line it doesn't work out, would you limit to the number of seating outside if it were to be turned into just a plain restaurant?
We're starting to speculate. We don't think that it will fail. If we did, we wouldn't be spending this amount of money on it and risking so much. It will not fail.
The marketplace it's a different matter. Your clients would be spending a lot of money on a venue. That venue can have multiple purposes. As a town council, we're concerned that should it fail, would you be then wanting to sit 350 people down in a restaurant there?
I'm just repeating myself. It will not fail.
Okay, so you wouldn't be
We're
prepared
going round
to...
in circles, I'm afraid.
But you wouldn't be prepared to put a limit, should it not be used as a marketplace, on the number of places for seating?
Chair, I can just repeat what I've said 3 or 4 times.
But so you wouldn't put a limit, you wouldn't be prepared to put a limit?
If it fails, it fails. If it gets a licence.
And if it gets planning?
We'll not mention planning. Right, I think that's it. No more questions. We'll adjourn for tea. 45? 2:30? Yeah, 2:30. Don't be late, because we haven't got much time. Welcome back, everybody. It's just to inform you all, it's been pointed out to me that some of the members of public are murmuring in the background, you know, while we're speaking. It doesn't matter to us, but it's being live streamed, and the microphone's picking it up, sort of. So just be aware that everybody may hear you, not us, but people on watching YouTube may. Right. Nearly forgotten where we were. It's that long since we.
YouTube, you'll see.
Oh, yeah.
I think Chair, if it assists, I think we had finished with the questions of the applicant.
Yeah.
So now we're moving on to the interested parties.
I think the interested, no more interested parties. Questions anyway.
Yeah. So in that case, I think we need
It's,
the interested parties. I think there is a time issue with Mr. Kemp's witness, who he's got, so perhaps it may be appropriate if he goes first.
Could, yeah.
The time issue is that Mr. Harvey Clark, who supplies the alternative acoustic report, isn't available tomorrow. That's the time constraint.
Could he present now then?
Yes, he can.
Right. Great. Thank you.
Well, in light of that, what I'll do is I'll make very brief representation, because I represent Philip George Walton. His objections are at page 267 of the bundle. In my submission, I don't think they need, pardon the pun, to be amplified. They are detailed to a degree. He lives, I think it's fair to say, to the north of Rialto, and therefore it is in close proximity. But I think it's fair to say also that he is not the closest when it comes to noise, but nonetheless, geographically, he is not far away, I would suggest. As I say, those are detailed. They make reference to various policy documents and also a conclusion. And therefore, I think, Chair, I would only be repeating that upon which the committee will have or will read in any event. With that in mind, I'm going to ask Mr. Harvey Clark about his report. He has a microphone right next to him, so that will prevent him having to stand up if you are content.
You switch yours off when everyone else is speaking.
Okay. Do you have a copy of your report in front of you? Right.
Switch yours off.
Well, of course, I'm going to ask him some questions just to assist, Chair, but I will switch mine off when he speaks. Sorry.
That's great, yeah. If you could do that, please. Just stops interference between the mics.
Can I ask you first, Dr. Doherty mentioned that he queried or was critical, whatever adjective you so desire, with regards to your methodology of assessment of the acoustics of what is called the orchard, because as he explained, there would be what he referred to as booths, which would have some form of acoustic lining, and also we can see on the plan two serveries as well, and that may or may not affect the sound emanation from the property. Can I ask you to comment on that, please?
Yes, so our model in our report includes a 6-metre high barrier from the ground to the top. And if there are other barriers in front of that barrier that don't obscure the line of sight to the top of that barrier, they will have a very little or limited effect on the sound transmission. So it's likely that they may have a very small effect on the overall sound transmission, but that it would be very small. By very small, I mean less than 1 dB. So not a detectable difference in any way. So.
And just for explanation, dB is decibel, is that right?
Yes.
Can I ask you to turn to page 13 of your report, please, which is your conclusions. Chair, do you and your colleagues have that? Because I think there's some errors in. I'm grateful. Prior, just above that is 11.3, where you comment on the condition that is proposed, where you say the applicant has proposed a condition that music noise is inaudible at the nearest noise-sensitive location. It is agreed that this is an appropriate principle to be conditioned and proposed quantitative description of audibility suggested. Then you say this: however, this condition places such a significant constraint on music noise levels that live entertainment is considered to be entirely impractical. Recorded music would need to be limited to a level of 67 decibels at 5 metres from a loudspeaker, and this is likely to be lower than the noise from the patrons themselves. So, if you remember, I asked Dr. Doherty about violins and the decibel reading from that. I think it was about 85 or something.
80, I think, was the number that...
Right, okay. How would you blend that into your conclusion at 11.4?
Yes, so these are actually consistent statements. So this says the same thing that Dr. Doherty claimed, is that the music noise would need to be limited to around about 80 dB at 1 metre. And this is equivalent to a single violin. And in fact, a single oboe would exceed that criterion. So that's the extent of the constraint on live or reproduced music. So it's so, in my view, so onerous as to be impractical for actually any entertainment.
So would it be, therefore, if music needed to be heard by the patrons, the volume would need to be increased?
Well, yes, if it was recorded, if it was live, it would be very difficult for live performers to play that quietly, in effect. It would be very difficult. Performers want to be heard. They don't want to be not heard.
And therefore that would be above 80 decibels and therefore would be audible at the nearest property. Is that right?
Yes, it would exceed the agreed criterion, yes.
At paragraph 11.5, same page, you say this: even with a 6-metre noise barrier, the noise from patrons with 350 capacity outdoor drinking area is considered to constitute a perceptible change to the acoustic environment, which may have a detrimental effect on the quality of life of the surrounding residents. So what you're saying is that at capacity, or maybe perhaps even less, general noise would emanate from the premise to the nearest residential premise. Is that right?
Yes, that's right. So I know there's been a bit of discussion about how many people might be talking at any one time. And we've followed some industry guidance, which actually has an average number of 1 in 3.5 people are talking. So a group size of 3.5. And we've assumed raised voices. And in the way that we made that assessment, we actually came to about the same level of noise from patrons as Dr. Doherty did, using a different method. So although he made different assumptions about how many people are talking and how loud they're talking, our assumptions ended up to be very similar. And this is clearly audible at the nearest noise-sensitive premises. So although it's below the background, it's still clearly audible. So it changes the acoustic environment there. Has an impact.
And of course, at the beginning of that paragraph, you said, even with a 6-metre noise barrier. Again, correct me if I'm wrong, it must therefore follow that if there is no 6-metre noise barrier, the audibility is going to increase at the nearest residential premise. That's right, isn't it?
Absolutely, yes, it would be significantly greater, the impact.
And you sum up, I think it's correct, at 11.6, it is considered that proposed activities are acoustically incompatible with the acoustic conditions proposed by the applicant. Is that right?
Yes. That's referring specifically to the music noise, because the condition just refers to music noise. It doesn't refer to patron noise. So.
Okay. That's all the questions I have for Mr. Harvey Clark.
Is that all you've got to present? I don't mean it like that. Are you finished with your presentation?
Yes, I'm not quite sure whether
On that
anybody
one.
has questions of Mr. Harvey Clark, but that's the presentation on behalf of Mr. Walton.
So he's here for the rest of the day, presumably?
He is.
well, hopefully, if there are any questions from the other side, we'll be able to get them answered today. Would you like to present your objections?
I think, Chair, I think that is Mr Kemp's presentation in respect of
that was it, right.
his client.
Yes, I've made reference to that submitted by Mr Walton. And also we would submit the report by Mr Harvey Clark in relation to the acoustic and the potential nuisance that noise emanating from the premises will occur, which I will deal with in my final submissions.
Okay, so we now turn to the other...
I think we need questions of...
You want... Sorry? Well, we've got the choice first, yes?
Hiya, sorry. A bit of confusion there. I just want to pick up on one point, well, not necessarily pick up, but just clarify. I'm sorry, the throat's gone a little bit. Live entertainment is, and somebody correct me if I've got this wrong, but it's only on till 8:30 between Monday, Thursday and 9:30. Friday to Saturday, I believe. So one assumed, oh sorry, I'm just making an assumption, devil's advocate if you like, that at that particular time, it may well be that people actually, there's less people in there, they listen to the music more, they're probably nowhere near being as drunk as they could be later on, and so therefore maybe there's no sort of, people aren't making as much noise as if they would if they were competing with the music later on when they had too much to drink, of course. I mean, do you think that's a reasonable assumption, or, in other words, the points you're making about having to compete with, say, 80 decibels on a violin or oboe, or whatever it was you said, well, if they're just listening to the music, maybe there's no competition to that.
I think the music would need to be so quiet, there would never be an issue. The patrons would never be competing with the music because they would always be louder. They wouldn't hear the music, but you would still get the effect of the... when you talk in a noisy environment, you naturally raise your voice. It's called the Lombard reflex. So you naturally do it, you can't help yourself. And this would happen for the patrons. Not because of the music, but because of the noise from the other people talking.
Yeah. But it depends where, and I've lost my plan, it'll be here somewhere, where the musicians are actually playing it. So, for instance, if the it's right in front of us. That might be something I would like to clarify from over here first. Where exactly would the musicians or singers or whoever, whereabouts in this facility would they be performing? It's just relevant to what else I've got to ask.
Just to keep you fit, could you go to the microphone, please?
It would be based around the tree.
Right, so the tree
in front of the booths.
Okay, so a lot of the people, if they're based around the tree, the seating there's some seating nearby, but it's quite a lot of it is fanned out, spread out from there, and so therefore they may not be competing against the music if they say, I don't know what that distance is, 30, 40 yards away. I don't know what measurements are, and so therefore again, that's on the opposite end of the housing side, if you like. So would that not have an effect where they're actually playing? I mean, you made this report. Have you taken into account where the performance is? And I might as well ask two questions at once, because my throat's starting to go a bit. And the second point I want to make is, of course, we're talking about if they have instruments and if they have loud instruments. But a lot of the time, I think, as was suggested, there may be, say, guitars going through the amplified system of the actual venue, which is limited, so they couldn't go above that decibel limit. So sorry, I ask you two questions at once, but
That's fine. Okay, so the first one about the place where the musicians are playing. Absolutely, it is important where they are relative to the noise barrier, because if they're closer to the noise barrier, then the the barrier will be more effective. So that means they could make a little bit more noise and still meet the inaudibility criterion. But your second question, and so I've been trying to describe how much noise a musician could make to comply with this criterion, just so that you understand what that means. Because when I say a violin or a flute would be excessive noise, so anything which you amplify is going to be very hard to keep to that low level. If you play it through more than one speaker, you're adding to the overall noise level. So it would need to be less than 80 dB if you put it through more than one speaker. And also, if you distribute the noise around, then you haven't got the benefit of, if you like, the noise source being closer to the barrier. If you have some speakers that are further away, that noise is going to go over the barrier more easily. It'll propagate more easily. So actually the level that you would be limited to would be more complicated to work out, but it would be lower overall.
Okay, but if it goes through the amplification system of the possible premises, then if they then found that at the nearest point of residence it was too loud, they could turn the amplifiers down.
They could.
No? Or is that too simplistic?
No, absolutely. But in my opinion, it would have to be turned down to such an extent that it was entirely dissatisfactory for the audience.
And what about people who are just singing without amplification? I mean, that's sort of like just like having two people talking then in that case. Or
exactly. That's the level of music that this site can tolerate, is one person talking it with a very loud voice.
Okay, thank you.
Thank you.
Okay, next. Sorry, the names have gone. Solicitor representative. Oh,
Sorry, Chair. I think,
sorry. Well, you can ask questions later on.
I think, Chair, I think each interested party will put their representation, then it's anyone's questions of that interested party before you move on to the next interested party. Right. So if the applicant has questions of Mr. Kemp or the noise expert, any of the other interested parties, residents, are obviously included in the interested party. So we deal with that before we move on to the next.
Okay, sorry about that. Have you any questions?
Just one, and excuse me, I've been looking through the documents, but I can't find it. You're here to represent Mr. Walton?
Yes, correct.
We're talking in the main, you've been talking in the main about the wall and the nearest premises, which is not Mr. Walton's. Mr. Walton lives to the north. What sort of sound would Mr. Walton hear? How many decibels?
So, in what our report shows, but it doesn't detail this in detail, is that if there was a band playing, then that would be a nuisance at his property. That would be 10 decibels above the background. That would be considered a significantly adverse impact, and that would be a nuisance. If that would be a band with drums, because we didn't know what the applicant's intentions were in the round when we started this. So that was, so obviously when we started looking at it in more detail, we can see that the greatest impact is to the residential houses to the east.
Thank you, I appreciate that. Would you imagine on a lovely summer's evening, can you remember them? And somebody sat outside at the Diamond having a drink, would they be able to sing along with the band? Would they hear it?
If there was a band playing at Mr. Walton's house, absolutely, he could, yeah, so he could hear every word of a band playing, yeah.
Thank you, that does help.
Thank you. Richard, right.
You say at 2.1, this report has been prepared in support of objections made against the application. So your job was to come up with a report that reflected the position that Mr. Walton has taken. That's correct, isn't it?
That's correct, yes.
So how do we know that this report is objective?
This is, I would do the same report if I was working for the other side, if you like. So my work is objective as far as it can be.
You understand why I made that point. Your council made a similar point towards our noise expert, but you see the point that I'm making. You've been brought here with a job in mind, and that's to support Mr. Walton's objection, yeah?
That's correct.
Yeah, okay. In your report, you haven't taken account of the buildings which are between our site and Mr. Walton's property, have you?
I disagree. Actually, we have, and you can see those in the model, and you can see the effect of them in the noise plan. So if you look at figure 5, oh no, sorry, figure 6,
Sorry,
on
which
page 10. That's a 3D perspective view of the noise model. And then if you look at figure 7 on page 11, you might recognise the gap between the buildings. So you can see an orange flame of noise, if you like, which goes directly towards Mr. Walton's house.
In preparing your report, though, I think you've assumed, have you not, that we will be working at full capacity, 350, and also we'll have bands on, is that right?
So that model, that noise model in figure 7 is based on a band playing, yes.
So that figure there, model 7, sorry, your modelling, doesn't really help us, does it? Because we're not going to be having bands.
Well, I agree, you can't, because you can't possibly meet your proposed condition with a band. I agree, so yes. But that needed to be demonstrated, because I don't think that was very clear from your report.
You think that the condition that we've proposed will mean that the noise play, or the level of noise within the premises, the orchard, will be very low, is that right?
That's correct, yeah.
So isn't that a perfect condition then?
It is, if you think you can comply with it.
Well, we do. Okay. Thank you.
Any more questions? Any questions from the, excuse me, members of the public? Yes, sir. Bear in mind it's questions.
To the acoustic, Alan Atkinson, again, resident of Ponteland. Question to this gentleman here. You mentioned that you were measuring 80 dBs at 1 metre from a speaker. Can I ask you, if you look at the concept of the orchard, how many speakers would you expect to see in the orchard?
So are you referring to loudspeakers?
Loudspeakers, yes.
Well, how many would I expect to see?
Yes.
That would depend really on the design of the public address system for that venue. So that's for the applicant. Really.
I'm basically asking for a subjective answer to, you're looking at an area of whatever it is, 24 metres, 30 metres long, 20 metres deep. If you're putting a sound system out there, even if it's only going to put 80 dBs, you would expect to have, I'm looking at that, and I used to play in a band, I would have said I'd expect to see at least 6, possibly 8 loudspeakers in that system. I'm asking you, as more as the expert, what would you expect to see?
I'm not actually an expert in sound system design.
Right.
So I couldn't comment on that specifically. But I would say that if you had 6 speakers, for example, then you'd have to limit the noise level from each one to less than 80.
So at which point you can have a conversation and not hear anything on the in terms of music.
You can't hear the music. That's right. Yeah.
So if you want to hear the music, you've got to at least have. I appreciate 80 dBs is pretty normal standard ambient noise. You need it louder than that if you're going to hear it. Am I correct in saying that?
Much louder. It's equivalent, like I say, to one violin playing.
Yeah, it's nothing.
No.
But you've already said that if you've got 6 speakers at 80 dB, the level now is much higher.
That's correct, yes.
Can you give an approximation on how higher it is?
Yeah, I mean, so if you double the number of speakers, then the noise level increases by 3 dB.
Okay.
So if you went to 2 to 4, that would be 6 dB. And if you went to 8, that would be about 7 dB higher.
Okay, so the next question is to our friends over here. Have you thought about the sound system and how you're going to prepare this in the orchard?
If you're asking a question of me, I'm
Hang on,
happy to answer
one
it.
sec, the questions are meant to be to this party.
Well, it's basically related to, we're suggesting there's 8 speakers, which has a significant bearing on how loud the noise is coming from the orchard. We need to know the number of speakers if we're going to have a sensible answer.
I think, Chair, obviously, that probably should have been asked earlier, but if you think it would assist you, you can.
I'm happy to answer the question, Melanie, or Chair, if that assists.
Decibels was not 1 metre from one speaker, but was within the overall level within the venue. That was the thought.
And is it right as well that you can design a system, position the speakers, type of speakers, etc., which directs noise? It can direct it away from
Yeah,
noise.
to some extent, you will get you will have a general
So
noise
you can
level.
design a system that, to some degree, does attenuate noise escape.
Yeah.
So if I could just
Small degree.
reply to your comment about
Yep.
you're claiming that the 80 dB is in the area, the way that you've treated the noise in your table on page 6 of your report, you've got background music level maximum permitted 80 dB and transmission loss due to nearest house due to barrier minus 32. So you've got 48 dB and you've got the same transmission loss for a person speaking and the noise level is at 1 metre. So you've treated those sound levels in exactly the same way. So that implies, so I agree with what you've done, if you like, in that, but the only sound energy you have for the music is a single speaker and it's 80 dB at 1 metre from the speaker in a free field situation. So that's not 80 dB over a wide area, that's 80 dB within 1 metre of the speaker, and then the noise will drop as you go any further, with a further distance from that. That's what you've included in your calculations.
So I didn't quite understand what you were saying there, sorry.
Okay.
Yeah.
What you've done in your, although you disagreed with my suggestion that...
Sorry, so you're saying that, well, I think we're probably sort of getting into too much detail here, but if you had a microphone in the middle of the venue, you would measure 80 dB.
I disagree with that, and that's not the assumption that you've used in your calculation. So your calculation assumes that you have a single speaker and a microphone 1 metre away from it, and on that basis, you've calculated the noise at the houses.
Right.
That's what your calculations are based on, and you've done the same thing for people speaking as you've done for noise coming out of a loudspeaker. So there's no more sound energy allowed in according to your calculations than that. And I agree with that.
Okay.
That is the constraint.
Yeah.
So that's not 80 dB over a wide area at all. You maybe didn't realise that.
Well, no, it's not a question of not realising it. I didn't work it out that way. Anyway, yeah.
Have you any other questions, sir?
My question was, of our friends over here, how many speakers do they anticipate having in the orchard? Simple question.
Before you answer that, could I ask a question of this side? Just for clarity, the music that's going to be played, presumably it's ambient music.
There will be predominantly background music, just to create atmosphere. Occasionally, though, we will have music as entertainment, but always subject, no matter what we do, to that condition.
So the actual entertainment would be, as you say, around the tree area?
That's where, yes, that's where the musicians, solo or duets, probably, not bands, would be positioned.
So presumably, if people wanted to listen to music, they would go to that particular area to listen to it. And people who wanted to talk would be further back in the seated area, or where I'll call them shops for want of a better word. They wouldn't be interested in the music anyway.
Exactly that.
Right. So you're not playing music for the whole venue? No? No. Right. Fine. Thank you for that. I don't know if that answers your question.
No.
That,
I think Mr. Atkinson's looking for a specific figure.
I'm looking for
or
a specific number because
figure of
it's
how many
relevant to what
speakers
this gentleman said. If it's 80 dBs per speaker, and it adds decibel F3, I think you said, for 2 speakers. I mean, we're standing in here, similar sized area. We've got 4 speakers around us. We need 4 speakers to hear each other with amplified microphones.
I think, Chair, just in the interest of moving things on, if they have an answer to that as to how many speakers you're going to have or likely to have, but if you don't know, so you know, I think, but the answer, obviously, Mr. Atkinson's asked the question a few times now.
so you can't answer that question?
I don't have an answer because it's not there.
You haven't been there yet?
No.
So,
Well, yeah.
If I can say, I think the point you're trying to make is, as I understand it, if you had lots of speakers, they would need to be quieter.
Exactly. That's much quieter, and you would not hear any ambient music. Sorry. They would have to be much quieter. You would not hear any ambient music because you'd be talking all over everything, even with a performer. As I said, we're standing in a room of probably a similar size to what we're talking about, and we've got 4 speakers, and I heard someone say earlier they're struggling to hear already. So even here, without shouting, without making a lot of noise, we don't hear each other. If we're going to hear music in the orchard, it's going to have to be a lot louder than 80 dB. And I speak as a person that plays guitar and used to be in a band. You do not go on stage and turn it down. That is unheard of. Sorry. Sorry, no more questions, Chair.
yet these microphones out here have been picking up what people have been saying in the background.
Chair, that's the point that I'm about to make. We've got 4 speakers and we can all hear one another perfectly well.
Are there any more questions, Town Council?
About not having bands, but they still could have bands. But normally if there's whether it's one person playing guitar or 2 people playing violins, people are naturally going to cheer and applaud. Do you have information on the noise levels that averagely emanate as a result of that? And I'm speaking because this summer, Ponteland has had a major problem with noise from other establishments that I've been able to hear cheering half a mile away in my home.
I don't know how popular the performances would be at this particular venue, but maybe if they are, if it is families and it's family-orientated entertainment, then kids can get quite animated and enjoy it. So, but I can't really speculate on that. But the patron noise will certainly be audible. I mean, I don't think any of us have disputed that at the nearest residence. That's there.
Thank you. Any more members at the back? Yes, sir.
Stephen Dobson. Can I just ask you one question? 80 decibels, what would that sound like as if you spoke now to the level of 80 decibels?
The best idea I can give you, I think, is in the standard, that's a reference for one person talking with a very loud voice.
Okay,
so if it's not shouting.
So if I spoke across here now, that would be around about 80 decibels?
No, it would be more than that.
I'll be more than that?
You'd need to speak a bit more loudly than that.
Okay,
yes,
this level?
Yes, if you think, and so it's about as loud as a violin.
Okay, and that's the total sort of decibel level that the music could have?
Exactly, yes.
Okay.
To meet this criterion of inaudibility.
Okay, so that's not particularly loud. So like if everybody in this room now spoke, they'd pretty much drown out that music.
Yes.
Thank you.
The lady, yeah?
Within the last month,
Would you like to go to the microphone, please?
within the last month, I have had...
Sorry,
can I just-
sorry.
Sorry, can I just double check? Is it a question to the...
I'm not used to using microphone.
Okay,
No, just,
all right. Can I just,
Okay.
can I just stop you there? Is it a question to the interested party? It has to be a question. You will get your chance to say and have your representation, but it has to be a question.
It is related to what we have been hearing.
A question.
a question though.
Yes.
Great, thank you.
But within the last month, I have heard music emanating from the centre of the village in my sitting room in Duns Green. Why is that possible? Why is it necessary? And I'm not the only one to complain about this disturbing the daily life of our residents. Thank you.
I think obviously that is a question that you've had some noise, perhaps nuisance, or you've been interrupted by some noise in your living room where you live. However, the actual questions need to be about this particular application. It's not general noise in Ponteland, it's about this application and the noise that would be created potentially from this application, and those premises aren't running yet. So you need to ask a question about noise to do with what they're proposing to do here.
As an example, for people who have no idea how daily lives can be affected, I see no reason why you cannot take this into consideration. It heightens your awareness.
But the noise is coming from other establishments. We don't know how much noise is emanated from those establishments. Possibly what should have been done, a noise test should have been done on the other establishments, on the Diamond, on the Blackbird, to see how much noise they emanated. Because seemingly...
It doesn't matter where the music or the noise is coming from. Think of the occasion when we have Party in the Park. A lovely day with lots of music, lots of noise, but it's a one-off. This is not something that's happening on a regular basis. I'm just trying to broaden our understanding, and if you can't accept that, then I do regret that.
I think what the things that you're saying are for your representation. It's not really a question for this particular noise expert, because obviously he can't comment on whatever's been going on in Ponteland throughout the summer or whatever. He's here in respect of this particular application and any noise issues that may or may not be there in respect of what is being proposed to be on the ground at the back of Rialto.
Okay. Have we any more questions from the members of the public? None? We'll press on then.
I think, Chair, I don't know if either Mr Holland or Mr Gwinnett have any questions.
I just have one question for the noise expert. We've had a lot of exchange about the minutiae of decibels and speakers and control, and these are matters of mechanical control, my words. Can I just confirm in your report, it is your view that customer sounds of people attending this venue alone will cause a nuisance?
When you say cause a nuisance? That's obviously, no, so our assessment is that the noise from customers alone will change the acoustic environment. So they'll be clearly discernible, and this will have an impact on the people living nearby. Whether or not it's a nuisance will depend more on whether they're chanting or whether, you know, how that noise is managed, if you like, at the source. So it definitely could be a nuisance, but I wouldn't say that it will definitely be a nuisance.
Yeah.
Higher again. Sorry, I've got Paul in my mouth for my throat, but never mind. So, getting back to what that lady said over there, or based on what she said over there, and what the chair said, are you saying that the noise that is going to be, possibly emanate from this venue, if it was granted, would it be noisier than the noise that is already made by other establishments within the village at this particular moment? I know you haven't done it, but as the chair said, maybe that is something we know. So for instance, if you suddenly find that this is well over 80 decibels, but in actual fact the other ones were well over 90 decibels, then is there anything discernible between the two? Maybe that's something we should know.
So I'm not aware that any of the other establishments have a license for outdoor music. Do you know that? Or?
I believe that information, some of the objections that's come in state that there are other premises within Ponteland that have similar issues to what they perceive would happen with this premise. So by that, I logically assume that there is more than one source of possible problems.
So I think, so I don't know, but I imagine that the people have certainly told me about hearing noise breaking out of other venues, but I would assume they're breaking out of indoor spaces when they leave the windows open or the doors open to provide ventilation, because that's a much more common thing to happen. So that's badly managed venues, if you like, failing to contain their own music noise. And I know that music noise has been reported, and that does happen at the minute. That's a very different situation, of course, from an outdoor music event.
I understand that, but as I said, reading through the 102 comments, a few of them do say that there is outdoor music at certain times in certain other venues. I mean, maybe not every night, obviously, but anyway, I mean, I don't know that myself for certain, but I'm just going off.
Councillor, we might be able to help you with that if that's an important point.
Carry on.
We know that there is another venue nearby that has rock bands on outside, and we know that that is causing a nuisance. We're being told that. But that's a rock band. We're not playing rock music. We're not using bands.
Thank you for that.
I'll leave it at that, thank you.
Right, we've established, we are where we are, sort of thing, right? Okay, would you like to present your case? I don't know which one's going to do it. Put your case forward.
Well, Chair, I'm conscious I represent a trade objector, and I'm always keen to defer to residents first. I don't know if there are any residents who want to go before me. I think my client might very well have instructed council, but
right.
we're well aware that we're not trying to sleep in the area, so to speak. So I don't know if there are any residents who want to go first.
The gentleman with his arms folded, I think you spoke before, didn't you? Me? Oh, no. Oh, was it? Yes, it was you that got it before. But to the mic. Sorry.
It's all about the disinformation that was going on before about the gentleman said about the rock band. That was once on a 60th birthday party. There was a Queen tribute band for somebody that had organised his birthday party with us. As for the character assassination of my daughter, poor kid who was sitting there, I'm not really au fait with Facebook, but she got her information straight from Mr. Meir that this is going to happen, and she put it on Facebook because normally when the first application went ahead, you see the blue notice in the window, nobody notices. So she decided the second application, or I asked her to do it because not Facebook aware, we'll wait for the blue notice and tell the local residents what's happening. Nobody knows this was going to happen unless I'd asked my daughter to put it on Facebook. So there was no malice or forethought. It was to try and inform people and residents of Ponteland. Another point is that I am a resident of Ponteland. I live by the golf club. Mr. Meir lives with a Throckley postal address, and Mr. Holiday has a Kenton Bank foot. So they're not really residents of Ponteland anyway, but they want to do it for the residents of Ponteland, not themselves. That's all I have to say on that matter.
Thank you. Any other members of the public would like to say something? Yeah?
As you know, I represent Ponteland Town Council, and I've said before, we do work hard to support local businesses, and we use their services where possible. And we've noted, and we're very concerned, because Rialto's has a long-held reputation as a responsible family-friendly restaurant. Now, Mr. Arnott described Ponteland Town Council's comments on the licensing representation as a half-hearted objection. It wasn't objection, it was a representation. Everyone has received late plans and late representations, and I feel we would have expressed stronger our concerns if we'd had access to the full information earlier. But our comments are based on licensing alone, not planning. But we do have serious concerns about the size and nature of the proposal as it is now. This is the third time I've met with the applicants, and the plans and scale have changed considerably from a small outside friendly area with just a couple of stalls to a full-scale marketplace. We've had reassurances about operating times, but we do not believe these will be binding. And if the nature of the establishment changes, we feel that these promises could be broken for commercial reasons. We want to point out that there are a good number of residential properties very close to this venue, a lot closer than your client, Mr. Walton. There's an old people's development immediately opposite, and work's due to start on that imminently. At the first meeting I attended, the applicants said they were basing the concept on what they described as the successful secret garden operation in New Hartley, which was opened in April. In July, they said they were basing their ideas on the old boathouse stalls in Amble and on a development and a venue in Richmond. In the notes accompanying this application, they say they took their inspiration from Altrincham Market in Cheshire. Whichever was the original source of the idea, these towns are very different to Ponteland. We're a village, we have no tourist trade, and we have no notable attractions to draw visitors. And the applicants have said that they're trying to carry out business with local residents. We don't consider that there are enough local residents to support the bakery, the sweet shop, the coffee shop, and so on. Local businesses in Ponteland are suffering. Actually, COVID has done them a lot of good because people have stayed local. The Town Council questions whether there would be sufficient local trade for these to prove profitable. If they were to close down, would this not simply allow further space for more tables and more patrons, thus altering the promised nature of the venue and raising concerns about noise and potential disturbance? The Town Council is seeking a maximum number of seated patrons, based on the plan submitted here, and we would request a maximum of 150. The Town Council is worried about the potential for public nuisance and disturbance for nearby residents in general. Other venues in Ponteland have caused a good deal of disturbance on occasions this summer, with police visits, a large number of complaints to the Town Council and complaints to the County Council. I've made several formal complaints myself, and I live half a mile away from the village centre. There's been excessive noise. The noise in Ponteland travels a strange way. It travels up the valley behind the shops and behind Cheviot View. If you were to come onto the main road, where actually Mr. Walton's premises is, it's actually not that noisy, but you go behind the premises to where there are a lot of residents, and it's actually noisy there. Residents, including myself, are rightly concerned about the potential noise from the outside venue. There has been noise from other venues, which, as far as I'm aware, the County Council is looking into. There's been conflicting information about this, and the applicant's expert report does not appear to have considered patron noise, cheering, applause, and so on. And that has been one of the main sources of disturbance, you know, with tribute bands. You know, I could sing along to ABBA songs in my garden half a mile away. Yes, if there are 4 people at a table at one time, only one will talk, but 4 will happily sing happy birthday or cheer a football match or applaud a singer. The major mitigating barrier to noise appears to be the proposed 6.1 metre fence. This is in a conservation area. It's obviously going to be subject to planning, but with my limited knowledge, you know, whether that will be passed is a dubious matter, but that is subject to planning. The Town Council has concerns about public safety. There would be a big increase in traffic from patrons' vehicles, from taxis, from pedestrians. It's already quite a dangerous area. We've had various complaints about people visiting the bank with vehicles going into that area. It is a very narrow access. So we are concerned about public safety, but obviously highways would probably have bigger presentations at the planning.
Could we forget about planning, please?
Yeah, I was going to, basically, I think there's a lot of people think the Town Council isn't supporting them, but this is just licensing, and planning is a very different matter.
Could you just stay there a second? Have you any questions to the Town Council? You?
Not that I can think of at hand, but I think what you have done is demonstrated one of the big problems most people have here, the distinction, and I'm repeating myself from earlier this morning, between planning and licensing. And they're 2 different vehicles totally.
Richard, you had a question?
Just a couple of questions. You said that keeping people in the village is a good thing. We would agree with you.
Sorry, they're doing what in the village, sorry?
Keeping people in the village, so they shop in the village and support local businesses. So,
We're not keeping people, supporting local businesses.
yeah. So why then is this a bad idea if it gives people who live in the locality another reason to stay local?
Because we don't believe that there's enough traffic. You know, on a Monday to Friday, children are at school. Yes, there'll be some, maybe there might be a few mums, you know, with children, a few grandmas with children, but we're concerned that this is not a valid idea. And if it is a valid idea, if it works, great, but we're concerned that should it fail, what would the plan B be? And there are a lot of people have concerns that the plan B could be to turn it into a big eatery, which you would actually have planning permission for, or a license for, if this were granted.
And you were concerned that the timings and things like that would not be binding. Can I assure you that they would be binding, because they would become part of the licence if it's granted, and they would bind us and anybody who followed. So everything that we have described in our application would become entirely binding, and any breach would be a criminal offence. Would you accept that?
And, well, we've had mixed discussions about this. I'm not sure what the actual conclusion was. If the licence application is until midnight.
No. We've described the application. Well, first of all, the application has been consulted upon. It's out there for people to read. And we've made our application in a particular way, and there are conditions attached to it, and there are caveats to times which become part of the licence and are binding. And would you accept that?
I don't know. I don't have enough legal knowledge.
And the disturbance that people are experiencing in the village at the moment, that's bands, isn't it? An ABBA band you mentioned.
It's illegal. It's music that shouldn't be. The noise that is there now shouldn't be happening.
Yeah.
But it's been going on for a long time. Right. So residents are concerned that there could be more noise. Right. It's hard, once things are in place, once the licence is there, it's hard to stop it.
Well, 2 things. First of all, you're not blaming Rialtos for...
Not at all, no.
Okay, so that's other people then? Yeah?
Yes.
Right, okay. And presumably those other people don't have a condition of inaudibility, or if they do have one, they're ignoring it.
I don't know enough. All I know is the conversations we're having with the County Council,
right. So
who are concerned about the noise.
Does the fact then that we're prepared to give you this condition not give you some comfort? And if we breach it, It's illegal.
Yes, but yes, it does. It is a comfort, but we've had very conflicting views on the acoustic levels.
Right. But it gives you some comfort.
Definitely.
Yeah.
I think it's rather difficult, this one, because you've just admitted you didn't realise what time the place was going to close and that sort of thing. I think one of the problems has been that the jungle drums have been beating in Ponteland, and a lot of, as we've seen in some of the letters, there's a lot of rumours being said about, and it's defining what the actual truth is, what the actual application is. So we'll leave it at that. Gentleman at the back.
Chair, can I just say
Sorry?
that obviously any other residents have the right to ask a question of the town councillor. Sorry, I can't remember your name. And obviously anyone from this side for the interested parties as well. So I don't know if anyone else has a question that they want to ask the town councillor.
My apologies, I should have said that, but we've been so all over the place. Are there any questions from anyone else to the town council? Nope, great. The gentleman at the back, third time lucky. Oh, different gentleman.
Sorry, I'm not keeping anybody very long. All I'd like to say is, if you stand outside of Rialto's restaurant on the roundabout, and if you draw a circle, 150 odds around, I think there's currently 17 premises which are on licence and off licence. The village is absolutely saturated. Absolutely saturated. We don't need any more licences in the village. There's enough.
For one thing, I'm sorry, we didn't catch your name, just for the record.
Stephen Dobberson.
Sorry?
Stephen Dobberson.
Hi, Stephen.
We're absolutely, as I say, we're absolutely saturated. The only way that these premises can now become viable is outside influences coming in, people coming to visit, which they already are. I was at the applicant's restaurant on Saturday evening, and I was chatting to him about this, and he told me that the vast majority of people in there that night were not local, had all travelled to the area. If you open in a premises and it's got 350 people in there, the amount of people who are going to have to come into that to fill it is going to be excessive to the village. For transport systems, the noise that is going to be emanating from an open-air venue, if it's been anything like what it's been over this past summer, is horrendous for the people who live close by. I live probably 150, 200 yards away from the premises. Not from Rialto's, never heard any noise from Rialto's. It's been from other premises. But if you build an open-air venue behind that, it's going to contribute, if not overtake, especially with the 350 people in there. I was about a mile away during the summer from the centre of Ponteland, and I've got a recording of that, and I can hear the noise from the centre of the village. And that noise came from two of the bars. It was the Diamond and the Seven Stars. If that noise is travelling that distance, it's going to be equally travelling if it's coming from the orchard. I don't want that there. I don't want the noise. I don't want the people coming into the village. I'm a resident. I'm sure everybody else here today is thinking exactly the same thing.
Well, first of all, regarding plenty of pubs with inside and outside venues, it's not really a licensing matter. There's another one coming. We can't refuse it because another one's coming. I'm going to speak about planning now. It's like change of use to a fish and chip shop. And people saying there's plenty of fish and chip shops. Well, I'm sorry, it's competition. You can't refuse it, planning-wise, you can't refuse a change of use to a fish and chip shop, as long as the conditions are there and correct. I've forgotten what else you said now. The noise.
The noise from the venues.
Well, as was said before, it was noise generated from other places.
It is, but my point is the noise that's going to be generated next summer, if this goes ahead, it's going to be amplified so much more than what it has been this summer. Well, and that's having a detrimental effect on myself and everybody else who's here.
Yeah, there is a condition there. What number was it, 19? No, I don't think it was.
I think, Chair, I know you're trying to assist the Mr. Robinson, but I think probably we need to stick to questions rather than responding.
Debate, yeah, right. Well, I've got no more questions. What wasn't a question, it was a statement. Yes, sir, that's to this gentleman.
To our sound engineer.
We've just done that.
No further questions to sound engineers allowed.
Well,
perhaps we'll deal with everything else first and then come back to that. But if we can just try and keep in order. I think the Chair did ask if there was any more questions for the sound engineer when he had finished. And we can come back to you, but obviously we're dealing with residents' representations at the minute, and anyone that wants to come forward, there is an opportunity to question that person if anyone does want a question.
Have you got any questions? Have you any questions?
Yeah, what happened to the chap at the back?
This other chap got up instead.
Questions to Mr. Dollison.
Have you any questions?
No. Has anyone got any questions for Mr. Dobson before he sits down? No, thank you.
None. Right. Let's get this tidied up. It's becoming a mess.
There's a gentleman at the back.
Yeah?
Just a few comments. Atul Malhotra, 1 Runnymede Road. I'm not the Mr. Malhotra that had the wedding last week, by the way, so it's not me. I've lived on the estate for 30 years, and without sounding brash or rude or arrogant at all, I probably live in one of the most expensive houses in the northeast. But I find myself every Saturday, every Sunday, most weekends, clearing up broken glass outside my house. Runnymede Road, as well as Darras Hall, is one of the most sought after areas in the northeast. I don't deserve that. This particular venue, if it's granted, will cause further nuisance, antisocial behaviour, because the walkway, which is the back of the tennis court and the bowls green, will invite people walking up there more. We can dress this up as much as we want, but on a typical Friday, Saturday night, after 7, 8 o'clock, there won't be any families visiting this venue. It will be 25-year-olds plus. And I am one of the largest hospitality operators in the northeast, so I'm fully versed with licensing. I'm fully versed with conditions. I run some of the biggest venues in the northeast. 350 people is a lot of people. And on a typical Friday, Saturday night, if Newcastle are playing, I don't need to say much more. Lastly, with Richard's help, by the way, I'm opening a venue across the road from this particular prospective application, the old Barclays Bank in Ponteland. Richard very kindly secured licensing for me recently. Now, I'm all up for competition. There's nothing wrong with competition. I'm probably one of the biggest spenders in the village, where I support all the local operators, Stars, Diamond, Blackbird. I was in Rialto's a couple of weeks ago. I'm on the Darras Hall Estates Committee, but Darras Hall is a place now where I'm considering moving away from. I've got 2 little girls, 4 and 2, and I don't even go out on a Saturday night with the family because I'm sorry, but it's just not safe. I had to call the police last week because there was young out-of-towners from Kenton, from Kingston Park, drinking on the streets. One had a broken glass bottle, and I was threatened to get glassed outside 1 Runnymede Road. So
I can quite appreciate this, but it's not Rialto's that's causing the problem.
If you let me finish, no disrespect, Councillor, you're very good at butting in quite quickly. I'm not saying this is any of Rialto's fault. I'm making a simple statement. 350 extra people in the village is going to cause chaos. Simple as that. And we can dress it up and sit here all day and, dress it up how you want to. This will cause antisocial issues. Thank you.
Are there any questions to this gentleman from anyone?
Atul, how many bars and clubs do you have and pubs?
I've lost count. 15, 16 venues in the northeast, as well as 17, 18 care homes as well.
But you don't operate a premises like this, though, do you?
Similar one would be the 3 Mile in Gosforth, where we have got an outdoor teepee. The Runhead in Wrighton as well, that's got an outdoor teepee.
And I'm guessing neither of those premises cause antisocial behaviour?
No, they don't, because I would like to think I'm a respectful, good operator. I've got a good standing with all the local authorities.
Yes. So it can be done?
Yes, it can.
Yeah.
No more questions? Mel?
No questions. I'm just mindful that I think this lady in the blue jacket has indicated earlier this morning that she wants to speak, and obviously she spoke earlier, so I don't know if you want to go.
Have you anything to add to what you said earlier on?
Do you want to make your representation now?
I wanted to speak on my behalf.
Yes.
Yes.
Yes. It's the time.
Having lived in Ponteland since 1964, I cannot envisage anything more inappropriate than this application. The land in question is within and forms part of the Ponteland Conservation Area, being an area which is so designated to protect the special character, architectural features, historical significance, and value of the area to the community at large. It may be argued that the provision of extensive food and drinking facilities with recorded and live amplified and unamplified music on every day of the week over such a long part of the day will so alter the character of the area as to be completely unacceptable. Village infrastructure cannot support the significant increase in footfall and traffic. Noise emanating, as you said, from this central site would have a negative impact on the centre of the village, affecting homes, residential buildings, care and nursing homes, churches, education and leisure complex. Having taught at Richard Coates Secondary Middle School for 16 years, and as a governor of Richard Coates Primary School now, I abhor this whole idea which goes against the ethos of our conservation area. This site adjoins the River Pont. The question of pollution must be brought into question. Flood prevention work has been carried out, but people, especially if they are not residents, don't always act in a responsible manner. If this proposal goes through, the village as we know it will never recover. Thank you.
Sorry, can we just get your name?
June Atkinson.
Thank you.
Has anyone any questions to June? None? Okay, thank you very much. The gentleman sitting behind you.
Hello again. My name is Alan Atkinson. I am a resident of Ponteland, living up the lane from the proposed site of the orchard. I'm not going to go over much of the ground which has been covered by some of my colleagues, but one comment I would like to make is much has been made that the orchard is modelled on the marketplace in Altrincham. I would put out, I've never been to the market in Altrincham, so I can't comment on how it actually works. but I have looked online to see the pictures and see what days it opens, etc. And I would say it is open at least 6 days a week. It is always closed on a Monday, sometimes closed on a Wednesday. It only operates from 9 a.m. till 10 p.m. when it shutters down at 10 p.m. It does produce local produce and does things for the community, such as Tuesday is fresh local produce along with Saturdays, Thursdays is thrift and antique market, Friday is fresh fish day, Sundays is a traditional market which shutters down, comes at 6 p.m. It closes earlier than we are proposing for this. I find from what I've seen of the alternate market, it's in a town of 52,000 inhabitants, 3 times the size of Ponteland. It's in the middle of a large shopping conurbation. There are many large stores, such as Marks and Spencer's. We don't have one large store in Ponteland. It already has the people there to use the market. They're in there, footfall is in the town, shopping. It's a useful addition to the town. Now, I'm not totally against the orchard. I think as a concept, to use that piece of land, it's a very, very good idea. But to license it till 11 o'clock with 350 potential people, it's too many for the village the size of Ponteland. I'm sorry I can't agree with what's being proposed, although I do find the idea of using the land in the way it's been proposed a good idea. It's the licensing that I'm against, and that's why I'm standing here making my comments. Thank you.
If you'd just like to stay there. Are there any questions to the gentleman from anyone? No? You've got off lightly. Thank you very much. Any more residents? Who? Oh, yes, sorry. To the, we'll take the mic. Sorry, I forgot all about you. To the mic. Thanks.
So can I ask the question or can I make the statement?
You can.
John Hewitt from Duns Green. Where I live in Duns Green, very close to my colleague June, or my friend June here, we do hear a lot of noise from the centre of the village. It seems to be focusing, the buildings seem to reflect it up Callerton Lane. That's my perception. Whether that's reality, I don't know. But one particular or several particular occasions when bands are playing this, it seems to focus up the road. And as Karen from the town council said, it funnels in other directions as well. But I believe the buildings in that area tend to focus the sound in certain directions. So I was going to raise the question, is that true? But I'll just make a statement. This is my perception, that the buildings do focus the sound towards residential properties.
Would you like to try and answer that question?
That's probably more your perception. And if it gets quieter as you go up Callerton Lane, then any intrusive noise would be more apparent. So as you move to a greater distance from the main road that goes through Ponteland, that traffic noise, the background noise level might die down. So that would make any particular sources of noise more apparent.
So you're saying that these buildings aren't reflecting the noise, they're more absorbing?
It's probably not an effect of the buildings themselves, I would imagine. It's possible, but it's unlikely. It would be quite hard to design the buildings to do that.
Yeah, okay. Right, thank you.
Before you leave, have we any questions from anyone to this gentleman? No? None? Thank you very much. Right. Members of the public are finished, definitely.
Chair, I wonder whether we could have a quick comfort break.
Sorry?
Quick comfort break?
Well, yeah, we may as well. Sorry? Yeah, till 4. What I'm thinking of doing is, if we don't get this done, which I'm sure we won't do now, is coming back tomorrow, and packing in about 5 tonight.
Perhaps, depending on what my friends have to say, if we can
Well, see how fast we get on, yes. It would be ideal if that could happen. And, you know, the summing up isn't long at all, is it? No, we've got to, we have up to 5 days, isn't it? 5 days to make a decision, so we won't be doing it here, we'll be well, it might be here, it might not.
I think it's...
I'm just concerned that sometimes there's pressure. And
Yes.
I was hoping you wouldn't.
Oh,
I think certainly with short hearings and you know, more limited applications, it's often the way that the committee retires and then comes back after an hour or so. But I think obviously the amount of information that's been received and has to be considered, I don't think it's practicable for, again, for the amount of people to be hanging around. So the decision will be given within 5 working days from the committee making the decision.
Could I just raise one issue? Mr. Harvey Clark wishes to go if he can. Thank you very much. I'm sure he won't be insulted by that. I just don't want to say, yes, you can go, and then someone says, ooh, I've got a question.
Yeah. Are we all sure that nobody has any questions? Yeah? Public? None? Right, going?
Thank you very much.
Gone. Right, 10 minutes, well, back at 4 o'clock, 10 minutes. Right, welcome back again. We'll continue with the objectors. Would the two gentlemen like to put your case forward, please?
Good afternoon, Chair. I think I've drawn the shorter or longer straw, whichever way you look at it. My client is Northumberland Pub Company, and their representation submitted by my firm on their behalf is at page 101 of your bundle. I'm not proposing to take you through it line by line. I take it as read that you have read your papers, but simply that you can identify who my client is and what their concerns were. The purpose of these comments is to amplify upon the content of that letter and to draw together some of the threads of discussions we've had today where relevant issues have arisen and become more significant. We have spent a large portion of the day with acoustic comments, and though very helpful, I would not want to become so focused on that evidence that the larger picture is lost. This is a proposal for an external area with a capacity of up to 350 persons being dropped into the middle of Punteland village. And that is a huge development by any standard. And although we can look at these conditions, which were drafted by Northumbria Police, who decided to cover a number of issues, including noise, which was perhaps not their forte. But these are conditions drafted by somebody who is not here today, but adopted by Mr Arnott and his client and are presented as such. It is my client's position that the conditions relating to live and recorded music are not enforceable, and the protections, therefore, of imposing that condition on the licence for the benefit of the people of Pontypridd who may be affected is negligible. I would point out, even if the condition were enforceable, that it is drafted in such a way that it does not include noise that might be from raucous people shouting and yelling in the garden. It is drafted referring to regulated activity, and by definition, the live and recorded music, and this is not a matter of debate, it is simply not regulated. And taking those terms at face value means that this committee cannot regulate them. I don't understand why there would be any miscomprehension about that. I'm sure Mr Arnott will address it in detail in his summing up, and ultimately your legal advisor will give you some advice on that. But that point is very simple. What has become clear through the whole day, starting with Mr Arnott's first sentences of painting his client as some poor victim of a slanderous campaign against them, of misinformation, has been completely misplaced. The application that was submitted, without any arm up their back, without any input from anybody else in this room, described the application in a very narrow way. Their note that they say helped everybody understand and should help everybody understand what this was about was delivered once not the horse had bolted, but the horse had disappeared over the horizon, never to be seen again. And perhaps, on hindsight, Mr Arnott and his client may have decided to have put that in earlier, and that might have satisfied people. But we have over 100 objections. From my experience of licensing applications across the country, that is a very significant number of people who've been moved to comment on this application. Your common sense, which should not be undermined, is something that you would look at. Looking at all this, 350 people in an open-air environment in the centre of the village. That's what we're talking about. And each expert who gave evidence today conceded, based on artificial numbers that we can't guarantee, that there was potential for noise nuisance from those. The applicant's expert suggested 130 people for a capacity of 350, and absolutely no guarantees. I heard evidence from a statement from the town council representative, and I thought that was very telling and is part of the issue that many people have with trust with this application, in the fact that it has drifted and morphed and changed from pillar to post over the last 2 to 3 months. What you have today from Mr Halliday, I'm sure, is a very heartfelt desire for what it would be today. The evidence you've heard from others, however, is that's not really what it was a couple of weeks ago or a couple of weeks before that. And the conditions that you're being asked to impose do not guarantee the style of operation that's being put before you. They do not guarantee the addition of food stalls. These are on a plan that can easily change. They are not regulated. Granting the licence in the current format does not equal the orchard that you heard of today. It does not provide the comfort and support that many people have expressed of concern about this application. And of course, you are not a committee, nor any committee will just simply apply the conditions proposed by the applicant without question. So, at the very least, I would be expecting this committee, if you were minded and were satisfied that this proposal in the form described in Mr. was acceptable, we definitely do agree that it is. Do not agree with that. It is not at all covered by these conditions and strictly put in. If you grant this licence, it can morph very easily into other matters. This is going to be a family-friendly premises that we've heard repeatedly, but the police, by request of condition, and the applicant, by accepting it, appreciate that people who may not be their target audience, I think undesirables was the way they were described, will attend this venue and try and get access to it. When those people are turned away in the first few weeks, as they labour on with a belief that it is going to be a new shopping arcade of a a baker, so as long as you need a loaf of bread and a bunch of flowers, you've got everything you need, that those people will be turned away. My client and the other trade objectors here today have concerns about where those people will go next and where they will try and access. Premises that have not in the past required door supervision to protect their door feel that there'll be a potential change in the environment caused by this application. We have great concerns, and the applicant accepts that they cannot guarantee who's going to come. They remarkably explained that there's no market research. The applicant, a restaurateur of I understand great note, Mr Halliday has run pubs in and around the area, neither of which have run a market or a operation of this style, but are relying on their expertise in adjacent fields to tell this committee with absolute certainty that they know how it's going to run. My clients, and I think many of the residents, I'm afraid, have a great trust issue with that. And we will have great concern that the conditions and the proposal that you've heard today is not what's going to be proposed. We do not believe that on a Friday and Saturday evening in the summer or in the winter, now that there's a canopy cover over it, and I presume heating and matters will be installed from 9 p.m. in the night on a Friday and Saturday night, that they're going to have families sufficient to justify the operation of this premises. It will become a premises which is a target of people in their 20s and 30s who are looking for a different offer than that which would be attractive to a family. That is not wrong. They are not wrong people, but they cause and they have different issues. And we think that the crowd noise that will occur from those people is a significant issue that has not been taken into effect or into consideration, should I say. The application before you promotes a very simple condition. We will do whatever it takes to achieve this. From the evidence that you've heard from both sides, it would appear live and recorded music as a regulated entertainment is not feasible at this site. Background perhaps, but not as a regulated entertainment. Or what we would have previously called regulated entertainment before deregulation. What the premises cannot, or the applicant cannot control, is how those people, which could be up to 350 people, are going to behave while in the premises in terms of raised voices. People talking over each other. When you get up to numbers of 300 or 200, 300 people, naturally the cacophony of sound increases. People are having a great time, enjoying themselves. That noise rises, and then the residents who perhaps don't want to join in that evening have to endure that in their homes. That is a public nuisance, and this committee cannot grant a licence that is going to cause a public nuisance. You cannot grant a licence that's going to cause a little bit of a nuisance. If it's causing a nuisance, you cannot grant. When you're trying to make your decision, it will be grant, or grant with conditions, or refusal. Conditions cannot solve every issue. There has to be a situation where I regret that conditions cannot address these concerns and you must refuse an application. When you look at the conditions that are put in front of you, you have to judge whether they are realistic. If the applicant is delusional in thinking that they are going to get a 6-metre wall, that they are going to be able to control people there, you as councillors can say that that is not credible. You can weigh that and say those conditions in this circumstance, in this location, is simply not credible. The evidence and expert evidence been given to you today has not been sufficient, in my opinion, to give any comfort to you, or sufficient comfort for you to rely that the applicant knows what they're doing in this regard, can control it, and will prevent those issues. When it comes to crowd noise, it is incredibly difficult to get people, grown adults, on a night out or having dinner with their family, to put their fingers on lips and be quiet and keep it down. You cannot treat adults like that. They're not acting in an unreasonable way. It's simply the fact that they are automatons, they are going to listen to themselves, they are going to make their own decisions, and it's going to be impossible for this premises to deal with. This is an application for a 350-person external premises. A huge factor. If this was inside a building which had its own acoustic, that's a different matter again. What I'm asking you to do, committee, is to take a step back and look at the whole picture. Because, in my opinion, and my client's opinion, it is ridiculous what is being proposed here. And the measures being proposed will not address them and are, in themselves, ridiculous. Beyond belief. As an applicant, on behalf of applicants, I have instructed acoustic experts many times in the past to advise my client as to the challenges that they face and provide them with the options or a noise management plan to address those issues. That advice is only useful if it is independent, if it is reasonable, if it is believable. And when we ask for that, we expect our noise experts to come back with us and tell us what is the lowest impact in terms of capital expenditure, operational styles, to achieve those goals. A 6-metre high fence is the lowest this bar could be brought down, if that isn't a mixed metaphor. 6-metre high fence. When talking to the expert, however, it appears a lot of these suggestions didn't come from him, but came from the applicants. He was told about the 6-metre high fence. He was told 130%, although there was some disagreement about who pulled that number out of a hat. But it is simply the case, and both experts agreed, that the crowd noise could potentially cause a noise nuisance. And that is at low figures of about a third of its maximum capacity. We predict that on a hot summer's evening, on Friday and Saturday evening, that those capacities could climb up higher, energy levels raise, and that will cause a nuisance. On the issue of enforceability of conditions, your legal advisor will give you some excellent advice, I'm sure, on the law and her opinion, and that will be what you will listen to. But I would ask you to look at paragraphs 2.17 and 16.6 of the national guidance, which expressly raises the issue about enforceability of conditions in respect of live music, and that they are not enforceable because of deregulations of the law. You will read that in full when you retire. I'm not proposing to pull extracts for you. I don't want to be accused of editing the text, but I'd ask you to read both of those paragraphs in full and form your own view. I am not going to go to planning. I appreciate, I hear what the committee have said about that repeatedly. But of course, you have a job to do on your applications. And again, you're being asked to do is assess an application, which in our opinion has been very poorly put together, very loosely put together, has been extremely fluid and changed with the wind over the last couple of months. And that was expressed very clearly by the Town Council. The plan that you're being asked to consider today for an application filed in July was served on you 1 week ago. No single responsible authority looked at that plan and commented upon it. It is clear that the applicant has changed. I changed the design of what this was intended to be as how they've described it over the past number of weeks. I don't suggest that's anything other than creative ambition in changing it, but clearly what people have been told this application is and what it is being presented to you today appear to be slightly different, if not totally different things. And we're very concerned about the way this application has changed so radically up to practically the doors of this committee room. This 6-metre wall, these play areas, the change in seating, the additional, all coming in at the very last moment in what I think looks like a very clear attempt to get the application in a position that would be most attractive to this committee and not really what the applicant wants. They want to get the licence in its current state, which will give them the flexibility to change in the future to the other styles that they may envisage and want. And it is not a genuine reflection of this, the application as it currently stands. If you were minded to grant, and I hope you are not, and I'm sure many people in the room, the majority would share that view, these conditions are totally inadequate to ensure the style of operation. Unusually, amongst these conditions, we would ask for the premises to be built in accordance precisely with the submitted plans in terms of seating, in terms of the wall, etc., which is outside the red line, you may notice. We don't want a situation where items outside of the red line can disappear because they're not part of the licence. The plan as a whole, with its description, with the applicant proposing to bulldoze through a fence and somebody else's car park to create a through road that doesn't currently exist. All of those features are being put to you as measures which will mitigate the concerns and ensure no promotion or no undermining of the licensing objectives. You are being asked to grant on that very specific basis. And if you were minded to do so, which again, for the umpteenth time, please don't, but if you were minded to, all of those features must appear as conditions, as specific requirements, because you are being told that these physical features in the application are critical to the successful promotion of the licensing objectives. We do not want to see the committee grant a red line around a specific area and not have those issues or concerns covered. I'm going to turn to my client. Is there anything else you'd want to add particularly? I'm not going to hold you any longer than that, because I appreciate it's been a very long day, and I know we've taken some turns down rabbit holes. On behalf of my colleagues and myself, our attempts to talk about the acoustic evidence, etc., were to try and illuminate the issue further, not cloud it. If we've clouded it, we've failed, but we've tried to identify the issues with the application for your benefit. Thank you.
Thank you. Have you any questions, Councillor Session? No. None? I have none. Are there any questions from members of the public? Have you any questions, sir?
Christopher, can I politely correct you? You said that this plan, the new plan, was served a week ago, is that correct?
Yeah. That's when we saw it, yes.
Yeah, right. It was served at the end of last month on the local authority. So it isn't the case, please accept, that this is something that we thought of just a week ago. If the local authority have not circulated, and I asked that they did, then with all due respect, that's not our fault.
Absolutely. That is, just to confirm, because you know that's after the close of the consultation period, right?
Yes, it was.
Yeah, so no additional comments could follow legally about that plan after it was submitted. Is that right?
As you will also accept, the plan is smaller in footprint, so would be, in any exaggeration, less impactful.
This would last lawyery thing. We wouldn't accept that proposition. The impact is severe from that plan. And our point is that the plan has come in after the opportunity to comment on it has closed. That's our position, of course.
Would it have made any difference to your objection? No.
No. While concerns of responsible authorities who've been denied the opportunity to see what the true scale of the application was, and it may have commented more detail about it had they seen it. That is our point, Richard. But I accept we are that's supposition because they're not here today.
But you accept that they just haven't objected, and the plan that was served on them after the consultation period was of a reduced area. You'd accept that?
That's your statement, Richard. Thanks.
Well, you'd accept it. I mean, you can see the plan is smaller. Yes or no? The footprint of the new premises is smaller than the footprint of the application premises, of the premises that we made the application with.
It's 350 people. It's a very large site. I don't think the change is significant at all.
Since you're a reasonable chap, will you also concede that you've been a little bit unfair in suggesting that we've been making this up as we've been going along? Because the statement that you referred to, the statement that we circulated at the behest of the licensing authority, that happened in, I think, July, middle of July.
I was simply echoing the comments of the lady from the town council.
Right, but you said specifically that, you know, we've been making, what we wanted 2 weeks ago is not the same as what we wanted 2 weeks before that. You said that. But that's not fair, is it?
I think it's completely accurate.
No, the statement that we produced clarifying the application was in July, and nothing has changed then apart from the footprint of the plan.
That's you to put your client's case, Richard.
No, I'm asking you the question. Will you be fair and concede that?
Richard, I'm not going to get into an argument about it. Perhaps that's for your summing up, can I suggest? Unless the chair wants us to bicker on like this for another 20 minutes.
If you don't want to answer the question, that's fine, I'll move on. Your client has an external area, yeah? I know it's small, but he has an external area. That's right, is it not?
Yes.
Yeah, at the front and the back and as the side as well?
We tend not to use the rear area because it's too near for residential.
Yeah. But you don't, do you get complaints about noise from people just being out there?
We've never had amplified music ever outside,
Right.
even when we could only use the outside because of the reduced restrictions after coronavirus. We still cleared the entire site at 10 o'clock.
Yeah. But
Even when we desperately needed the money, having just reopened after coronavirus. And also don't forget, our nearest neighbour, of course, is of course the cemetery. So we tend not to cause a lot of
But you do, behind the church, there are people living there, and I think directly next to you, there's that nice parade of houses as well. So you do have very near neighbours.
We do, and we don't cause any noise, but then we don't stay up late.
Yeah.
And we don't have any amplified music
Yeah.
outside at all.
But you get no complaints about patron noise.
No, but then we are also very food-led as well.
Right, but you have people outside who are just drinking, and you don't get complaints, is that right? Right. And also, when it comes to these undesirables, you're able to manage them, aren't you, and keep them out?
Well, it has been problematic at times after reopening, trying to keep away people who don't want, and our worry is that this will attract a great deal more. And in all fairness, when Mr. Halliday was chairman of Pub Watch and YOLO opened, he was very vocal about the fact that he was bringing people into the area because they had door staff. He felt he got the trouble at the Diamond.
Yeah.
So I'm actually largely echoing what he has said in the past, only it's on a much greater
Yeah.
scale.
But that trouble didn't come to pass in the end, did it?
I'm conscious.
With the greatest respect, his comments were about specific events that he'd have to deal with. And when you're stood in that passageway leading up to this, between Lloyd's Bank and the sort of the shop that's boarded up, if you are turned away and you turn around, the first thing you're going to see is the lights outside Blackbird. And we want to be able to still be there, peaceful and riot, without the intrusion of others that we're not looking for.
Right.
I'm conscious that the questions you're asking are about the Blackbird, not really the application.
The point that I'm probably struggling to get to is, you can manage your premises, therefore, why is it the case that you say that Mr. Halliday and Mr. Meir cannot run theirs?
The style of operation we run doesn't attract as many people from outside of the
Right.
area. And it's not on the scale that they're on, and we don't need those numbers in order to survive. They will need those numbers, and they'll need their 350 in there.
No, I disagree entirely. Chair, rather than getting to an argument with Mr. Young, getting the hint, I'll leave it there.
Thank you very much. No more questions for... No. Right. We'll now move on to the middleman, please.
Chair, I'm the opposite of that. The point I'd like to begin with is obviously my client, Daniele Holdings Limited, is a trade objector, and as such, its commercial interest probably carries the least weight of the representations you've heard from residents. But we're allowed to be here, and the representation is at pages 133 to 142. Because there has been a drip feed of information from the applicant in this case, you couldn't have said less about this application than was provided in the description in the application notice itself. That the purpose of that notice completely failed because of the haiku-like efficiency of the description of what was going to happen, because clarification has only been provided in a step-by-step phase as we have moved through this. There are points where I have made comment on things like the layout of the seating, which was in a beer keller style, and that's no longer the case on the latest iteration of the plans. But the thrust of my client's representation made by me on its behalf remains. And essentially, I can nutshell this, that what we have an application for is a large outdoor wet-led vertical drinking venue in the middle of a village, trading at weekends until 11:30 at night. And my client is concerned that that's going to attract a demographic that currently isn't catered for in Ponteland, and a change in demographic at one venue can change the whole area. Mr. Malhotra sitting at the back of the room, the owner of the new Northumbria. When I moved to Jesmond 25 years ago, Osborne Road was a sleepy street with some hotels, with a tiny commercial bar at one end, and now it's a cumulative impact zone because bring in high volume vertical drinking and the lowest common denominator usually applies eventually. And my client is commercially worried about that. Yes, it will be competition, but it's also worried about the adverse impact on the licensing objectives that's going to cause, the blame that the whole hospitality sector is going to get for it, the conflict that it will have to deal with in terms of patrons disappointed or otherwise coming from this applicant's site at its door. So it's concerned about that, and it's concerned essentially that the demographic in Ponteland is going to change if you allow this large, extremely large by comparison to other sites, wet-led venue to launch. And it also has some experience, probably more experience than most, in launching outdoor venues on brownfield sites. So my client operates Stack at the bottom of Northumberland Street in Newcastle. There's a Stack in Seaburn, and then I know there are other Stacks in the pipeline in the rest of the country. Now, Mr. Arnott began this morning by talking about onus of proof, and essentially was suggesting that at law, the onus is on representors to show that this is going to be a problem. I don't accept that analysis. This isn't adversarial litigation. This isn't, I know at some points we've had lawyers' tennis, but it isn't adversarial litigation. It's a decision made in the public interest, with you weighing all elements of the public interest. My client's bank balance fairly low down the scale of what's important in relation to that. You must exercise your discretion to do what's appropriate to promote the licensing objectives in the public interest. And you're entitled to rely on any material that appears to be useful in coming to a decision that includes your own knowledge and your own common sense. If somebody wants, whether it's a meadow or a paddock or a piece of wasteland or whatever label Mr. Arnott thinks is important to attach upon it, if somebody wants to take the piece of land that you can see in the street photograph in my bundle, which has got trees and grass and is a fairly agricultural or countryside looking scene, if you want to take that and open a large outdoor wet-led drinking venue trading at weekends until 11:30 p.m, the starting point in my submission on any common sense basis is it's going to harm the licensing objectives. And onus, if there be onus, is on the applicant to satisfy you that it isn't, not on the representors to come along and unpick his case. The responsibility in my submission is borne by the applicant. And an example of this is my client's experience of opening box park venues like Stack Newcastle, Stack Seaburn. Those types of venues where we're coming in and we're seeking to insert regulated entertainment, retail, food and alcohol in areas where there were none. My client's experience of that is that there's a huge amount of pre-application consultation with the local authority, with the local planning authority, with environmental health. There's a significant amount of planning in the non-technical sense that goes on before licensing applications are made and licensing applications are heard. Now, I'm going to use the P word in the technical sense, and I know that causes everybody to recoil in horror, but I need to grasp this nettle. The applicant has, in my submission, belatedly, it might have been at the end of August rather than last week when we saw it, but only belatedly, late in the day, not during the consultation period, we hear for the first time about a 6.1 metre high, 100 metre long acoustic fence. It's only belatedly that we hear about noise limiters coming on amplified noises. The case has been changed, the scheme has been changed as the process has gone through, and we only need to look at the way the plans have evolved as various applications have been made. Mr. Arnott says, oh, well, that's a different application, it's irrelevant. No, in my submission, you've got to look at this holistically. You've got to look at the whole picture and see how is this applicant grappling with its responsibility to deliver a operation that can promote the licensing objectives, can not cause a nuisance, will not cause crime and disorder, will not harm public safety, will protect children from harm. And Mr. Grunert said a lot of things that I would be saying if he hadn't said them, and I agree with them. I'm trying not to necessarily travel over old ground and duplicate, but you are entitled to ask yourself, and you should ask yourself in my submission, are the solutions being offered by this applicant to deal with the there's no dispute that there's issues. They wouldn't be offering to construct the largest living wall in Northumberland, if not a considerably wider radius, if they didn't accept that. Are they realistic solutions or are they unrealistic aspirations? And if they are unrealistic aspirations, there are choices available to you as a committee, and that includes rejecting the application. You are allowed to say, go away, have a harder think, and come back with something that can properly be consulted on. I mean, Mr. Arnott says, we've reduced the size of the plans as we've gone on. We've reduced the footprint of the licensed area. And there's a case called Taylor and Manchester that says you can amend the plan to reduce the licensable area. And I'm sure that's what he had in mind because he's a very skilled and knowledgeable licensing solicitor. But in the meantime, they've built up, we've got an extra floor of area in relation to what Mr. Doherty, I know there was a debate about whether these were shipping containers or not. Dr. Doherty calls them that in his report, which is, I think, where I got it from. But, you know, they double in height. There's a 6-metre fence goes around the site. That's stuff that the regulation said should have been in the plans at the beginning, or needs to be put in the plans. And those things have been added. Yes, the footprint might have reduced, but the application has developed, it appears, in a belated attempt to deal with the obvious. And what should be obvious is that 350 people on an outdoor site, a wet-led site, going until 11:30 at night, is, as a matter of common sense, going to offend the licensing objectives, unless a very great deal of things can be done about that. Now, in relation to planning, I know this isn't a planning committee, I know there are separate disciplines, but the Section 182 guidance says there should be liaison between licensing and planning. Your policy says it would be preferable for premises to have an appropriate planning consent. In my submission, all the more so when it's as contentious as this. When you have half a kilometre squared of living wall in the middle of a village, one might think that's the sort of thing that everybody should have been told about at the beginning, rather than much later on down the line. And whilst you're not a planning committee, in my submission, you're allowed to ask yourself questions like, is it realistic that that will ever get planning? Is that something that planning should have been consulted on specifically? And Mr. Arnott volunteered that planners had been invited to a consultation meeting at the beginning, although I don't think that was a meeting when there was a 6-metre high acoustic wall in the offing. That seems to have come much later on. And options available to you are to simply refuse the application because you think the aspirations are unrealistic, refuse the application because this has been a moving feast and this really needs to be set out from at the beginning, or condition the fence. Condition the you can condition the license so it should not operate unless it's built in accordance with the plans, or have a specific condition that there be a 6.1 metre high acoustic fence along the line shown in the plans. Because one tactic, and all the lawyers here, certainly the ones who do, well, all the lawyers here, we're all taxis for hire. We'll take anybody's money and you know, There'll be times when the roles are reversed. I'm sure that there have been in the past and there will be again. One tactic is to say, well, look, let's get the license, then we'll go to planning. Planning will say there's no way you're having that fence, but you can use the license to say, well, the principle of regulated and entertainment is okay at this situation, so let's have that, but in a different way. And then come back to licensing and seek to amend and vary, and softly down the way you get to where you particularly want. And in my submission, this fence is bluntly absurd. It is absurd to contemplate somebody constructing a structure of that size and extent. And the conclusions you should draw are either that this application is just unrealistic or that there needs to be a specific condition in relation to the fence. In my submission, it's too dangerous to just say, well, it's a planning matter. The onus is on them. We'll grant, but they'll probably never get planning, so it'll probably never happen, and that's how we discharge the duty. In my submission, too much of a gamble, because this is a fluid system where there are the abilities to come back and make variations and make apply for variations of licenses and to take things away, and perhaps to ask for something very much that one knows that there is flexibility to work through. I mean, there are other, in my submission, alarm bells ringing about this. A noise condition with or decibels levels set that are simply commercially unworkable. You can't provide regulated entertainment at a level that's lower than the audience speaking. And conditions that aren't likely to work are conditions that are not likely to be adhered to. But it's, again, just a signal of an application, a very potentially risky premises if this is granted in its potential consequences. There are concerns in my submission that you should have, that matters that I suggest are objectively unrealistic are being offered. I don't suggest this wall isn't realistic. I suggest that the entertainment levels being suggested are unrealistic. And I know umbrage is going to be taken, or objection is going to be taken to me describing this as a wet-led vertical drinking venue. I can see nodding and flickering of eyebrows across the room there, but let's look at it. 350 people, there's only seating for 152. That's a vertical drinking venue in my submission. It's seating for a minority of those who attend. The most profitable time for any operator is trading at Friday and Saturday nights, and it is in the operator's interest to get as close to maximum capacity as possible, and the vast majority of people are going to be standing. The retail is extremely hard to operate when mixed in with hospitality. Certainly my client at Stack in Newcastle, even though it's at the end of Northumberland Street, even though people use it as a shortcut to go through it, there's massive footfall. Retail struggles there because customers, because people out for a retail experience tend to be very different people who are out for a hospitality experience. But we've got some retail, we've got some food. The food, certainly as described on the plan, is not fine dining, pizza, wrap and ties. It's cheap and cheerful in my submission, and essentially one can see just from the layout that the bulk here, and certainly if you look at the area given over to cellarage and the area given over to bars, that this is, in my submission, a wet-led operation. This isn't going to be people aren't going to be turning up at 9 o'clock on a Friday night and enjoying a relaxed Thai meal at the orchard. It's going to be drink-led. And to compare it to a market that's been the subject of hundreds of thousands of pounds of local authority investment and is a well-established market, in my submission, is a smokescreen. Christopher Hitchens, the late public intellectual, had a maxim that said what can be asserted without evidence can also be dismissed without evidence. So when we say that the majority of our patrons will be local, well, because we say it is, in my submission, to make this work, you are going to need a large number of people, who want to be in this cheap and cheerful outside area until 11:30 at night. That's an entirely different demographic in my submission to what currently exists in Ponteland. And I think it was very telling to hear the differing views of Mr. Holliday and his solicitor about football and screens, because that, as Mr. Malhotra said, on a Newcastle match night or some other sporting event on that occasion, that is an opportunity for an operator who can screen the match to make real money. And at the end of the day, whilst the operators have had a long experience in Ponteland, the money they have invested wasn't a gift to Ponteland in the same way that my client doesn't give to Ponteland. My client exists to generate profit for its shareholders, and it's an investment that is selfish, and rightly selfish. I don't mean that in a pejorative sense. It's capitalism, and they are there to make money. And this is why there's no way they're going to offer a condition that there be no screens and no live events and no football, because that is an opportunity to essentially print money on that site. And I suggest that that's an extremely telling moment in this case, because it's shown what the operator's true motives here. Yes, really fascinating to know that 6 trees make an orchard, and there's going to be this petrified tree there, and the sweet shop operator wants to come and sell sweets. But what is driving this is alcohol sales to 350 persons. And in my submission, there is a mountain on an applicant to climb to show that that's acceptable in Ponteland. And the suggestions that have come late in the day, they're not just unrealistic, but they don't actually deal with the issue, which is the changing demographic and the introduction within this village, essentially of a city centre style venue. So in my submission, you should refuse this licence as it relates to the orchard. I should make this clear. My client has no objection to the relicensing, and there is some slight amendments to the restaurant licence. This was the thing I was trying to help with earlier, probably unhelpfully. It doesn't currently have off-sales on its licence, although it does have the automatic off-sales extension under the Business and Planning Act of last year. But there's a change to make that permanent. There's a change to add an external area to the restaurant. Nobody's discussed this at all today, but we have no objection to any of that. So far as Daniele Holdings Limited is concerned, it is simply the park that we ask you to refuse that licence. If you're not with me on that, and I know this sounds a bit like a summing up, and that's because I'm not going to sum up. This is the last you will hear from me. I'm sure you'll be very relieved to hear. If you're not with me on that, the conditions, obviously the 350 capacity volunteered by Mr. Arnott, that needs to be made clear as to what area it relates to. The noise condition, inaudibility is subjective. I don't know if you remember when somebody invented a device that annoyed teenagers and nobody else because it operated at frequencies that older people couldn't hear. An inaudibility condition is subjective and it's unenforceable. And there's a case I cite in my representation, Developing Retail, where the Deputy High Court judge said because it's subjective, it's unenforceable, back to committee and put an enforceable condition on. And one was suggested by Apex Acoustics at 6:15 of the report, and I agree with that is enforceable. And again, I'm repeating myself now, I would ask it for a fence built in accordance with the plans if you are minded to grant.
Thank you. Richard.
It's very tempting. But Mr. Holland and I inevitably end up bickering. And I know you don't want to hear us bickering. So there are various things that he said that I would suggest are weaknesses in his argument, but let's leave that to my closing submission.
Okay, thank you. Any questions from the panel? No. Solicitor? Any questions from the members of the public? You've got off light. Well, it's now 5 to 5. I'll adjourn the meeting till tomorrow when we'll have summing up from both parties. But before we go, is there any member of the public who can't get tomorrow would like to sum up this evening that's spoken? Summing up is not going through the whole thing again. It's literally just hitting the main points. Is there anyone who can't come tomorrow? Okay. Then we'll adjourn the meeting. Thank you all for attending, and we'll start tomorrow at 10:30. 10:30.